seeking for inclusion. So this is complete. This
You
is a very
people do not appear. We include the matters. Yesterday also it was mentioned we included Danaf.
this was not
Hand over your slips.
Your Lordship, there are two mentioning one is regarding an appeal matter,
Criminal appeal.
criminal appeal matter, along with the application for bail matter for inclusion in the list. And second, Your Lordship, it's a one two bail applications have been filed, which is Your Lordship, this is for taking up the matters together. Two matters bail applications have already been filed and one is appearing on.
When is the return of it?
One
When
is
it is
appearing
appearing
on
on the list.
Wednesday.
Pardon?
So one matter is appearing on Tuesday, so the second for Wednesday. So I want the two matters to be.
Up to you remind us when we take up the first matter. It cannot be, we cannot change our direction. So you remind us, yes.
or relaxation of.
Yes. Yes, call the list.
Item 1. Item number 1, Mr. Jalpaiguri Mishra is arguing counsel.
Yes, what
But
depends.
this instructed me,
What depends in this matter, the lady has been recovered, she was produced.
Yes, Lord, it was if you lordship read it.
We have read the file.
This should be dismissed with court lordship.
Wait, sir, don't get so excited. Yes,
Mr. Jalpaiguri Mishra has urgently traveled to Sikkim. Kindly takes this up on Lord Martin. Traveled to Sikkim. He has instructed me for not. Kindly takes this up on
Monday it won't be possible.
any day thereafter.
Go to the next item.
This was already heard once before.
Where is the lady now?
Lady now, she became the Pradhan of the culture.
Very good, very good.
And
Now on Monday.
actually they have given a color into a criminal case by a heaviest purpose.
All right, we shall consider on Monday.
Monday.
Monday. Regular. So, why you have any problem on Monday?
No, I have no problem. So, but I am for the petition. I am paying for only not to do.
Why you sir?
But I am not getting dating. This past time I did.
Then we give whether if you can. The body depends on anticipatory vehicle. Vehicle button with the more. Yes.
Today. Item 3.
Password.
4.
Password. No, you done this 2 p.m. 3-4 2 p.m. Yes, Mr. Chakraborty, who is there for state in
The in case for I think for CD is not.
we keep it on at 2 p.m. Let us see. Your matter also 2 p.m.
One number 5.
Item number 2.
Can be taken apart.
No, we have kept it on Tuesday. 3-4 2 p.m. Yes, 5.
5.
Yes. What is the
Offense under section.
you have got it, Mr. Chakraborty?
Go and state it.
I did not find same thing, madam.
Tuesday. File is here. Case study is here. All right, 2 p.m. 2 p.m.
I'll come back the appeal, the election matters.
Yes, next.
7.
Where is Mr. Yes, Mr. Poddar, you are not ready. An adjournment has been paid for on behalf of the petitioner to the learned advocate appearing for CBI establish the matter before the next available Saturday.
8. 8 and 9. 8 and 9 Russian. 8 and 10 Russian. Civil is not. 10 and just pass. Only 8 and 9.
Today, your CBI will come today.
Mother.
Come today. Come back at 2 PM. Let us see. 8 and 9 2 PM. 10 you are there. Who is for the
Just 10 minutes.
who is the petitioner? You are there. All right. Pass over. Yes, Mr. Ram. Who is your other side? 2 PM then? 10 2 PM. 11.
12.
An adjournment has been prayed for on behalf of the petitioner to establish the matter before the next available Saturday. You are there in 11. Oh, 12. Yes, Mr. Poddar. Same. No, no, 11 টাই দিয়েছিলাম না? 11 টা কি করে? আচ্ছা, 12 an adjournment to the learned advocate appearing for CBI is present. Yes, 13.
Kindly make it on please. Advocate on record is out of session.
Then it will go out of the, it will go to the next. Then let it appear. On 6th, bill, it will be 6 তারিখ। You are there, 13. 6th.
I beg to appear on behalf of the petitioner.
Yes.
Worship, this is the service, affidavit of service that have some copy of the application has been served on the victim option.
Sir. No. Yes, tell us.
The allegations that have been leveled against this petitioner are section 10 and 12 of the POCSO Act.
The box with the doctor. Ten and 12. Next one is- Yes.
Lordship, the FIR is in Nepali. I couldn't translate. I could, due to urgency in filing of this application, I couldn't get it translated. But the summary and the gist of the FIR is, Lordship, the mother of the VG lodges this FIR. After a delay of a year, Lordship, there is an inordinate delay. And the FIR states that during the board exams of the victim, the present petitioner was the private tuition teacher of the victim. And thereafter, on reason or giving the reasons of extra classes, this victim was called and she was molested. And thereafter, the last para of the FIR states that we called the victim to our residence, we slapped him.
Why he? There are 2%.
The grandfathers and grandmothers were also in that residence, in the residence.
This is the principal accused, Praveen.
Give it.
He is the principal
He
accused.
is the principal. He is the principal and sole accused, Your Lordship. Now, the mother of VG says that we slapped him, and thereafter this matter ended right over there. We couldn't dodge the FIR at that point of time. We didn't initiate a complaint at that point of time because the health of the father was not well. And thereafter, in 2023, we come before the investigating authority to lodge a complaint.
Why? It was the occurrence was when?
It was in 2022, back in 2022, Lodge.
And the FIR was filed
On 12th of April 2023, Lodge.
month of April 23. Who lodged the complaint?
The mother of the victim, Lodge.
Why the petitioner was sworn arrested? He was.
Lordship.
He was
Yeah, Lordship.
just let him finish.
Lordship, the petitioner was sworn arrested because there was a case which was lost against him under section 10 and 12 of the POCSO Act in some other police station. But Lordship, in that
Different complaint.
another complaint. But Lordship, in that case, the petitioner is already on bail. Is already on bail because there was as such there was corroborative and contradictory statements made by the victim in that case, and that's why the learned trial court was pleased to pass an order of bail, Your Lordship. And subsequently, this FIR was lodged, and then I am behind the bars, Lordship, for almost more than 4 months. Lordship, the fact that needs to be taken into consideration of here is Lordship sees that in my statement before the investigating authority did not pay heed and attention to record my statement. My side of the story is, Your Lordship, that such an incident had never occurred. Such an incident had never occurred because why a mother will choose to, when such an incident, if such an alleged incident had occurred, why a mother will choose to send her daughter to me at my private in my private tuitions even after occurrence of such an event.
When were you arrested in the previous matter, and when did you get bail?
Lordship, I sincerely apologize. I do not have instructions in regards to that.
Yes, what do you say?
Lordship, this petitioner is a habitual offender, Lordship. He was arrested in case of Matigara Police Station 273 of 2023, dated 9/4/2023, Lordship. Same allegations, Lordship.
Different complaint.
Different complaint, Lordship, but the nature of the allegations are
When
same.
was the said complaint? Earlier complaint?
Lordship, earlier complaint was 9 April 2023.
9th April 2020.
Lordship. 9 April
This is also in 20.
This is Lordship 12th April 2023, Lordship. Delay has been explained in this
No,
case.
let us under in the 9th April, so there are almost consecutive complaints.
That is
One was-
different case, Lordship.
It was, first one was on 9th April, second was on 22nd.
12th April, Lordship. 12th April.
Yes. Now in the 9th April contempt, he has got bail.
Lordship. He was granted bail.
When was he granted bail? You do not. Did you refer to that? That was discussed in the charge sheet. Just let us.
That is a different case, Lordship. That was initiated under Matigada police station, and this case was initiated in Calcutta police station, Lordship.
But how could he have been shown arrested if it was granted bail? When was he arrested in respect of the first count?
That is not mentioned in this city, Lordship, since this is a different case, Lordship. But
He was shown arrested on 12th of April 2023.
in another case conviction, Lordship. This is a
That is why we are asking, when did he get the bail?
Lordship. That is not mentioned in this city, Lordship.
The girl is aged about how many years? But he has ছবি তুলে নিয়েছে। You have seized the mobile, na?
The mobile of the
Did you find anything there?
nothing as such. Lordship.
Lordship, he showed some indecent photos and Lordship videos.
Showed to the girl.
Shown to the girl, Lordship. Same allegations in Matigada police station case and same allegation in Kashyap police station. She is a habitual offender, Lordship. Kindly read the 164 statement, Lordship.
Charge sheet submitted.
Yes. Charging has been submitted.
Where is the one?
Yes, Lordship.
One 164 is that page.
Page 57.
Any medical report?
Page 12 is the emergency ticket, Lordship, no injury because.
Now, what is the explanation of the delay?
delay has been explained, Lordship. The father of the victim, he is a kidney dialysis patient, Lordship. Delay occurred because of the illness of the father of the victim, Lordship. That has been explained.
1 year. After 1 year complaint lodged. Then the first complaint,
9
here incident was in May 2020 in this complaint. And in the other complaint, it was 9th April 2023.
Lordship.
So that case diary is not with you.
No, Lordship, that is a different case.
Different case. He has been granted bail in that.
Yes, your lordship.
FIR of that case, Lordship, that has been that is in the CD, Lordship, the earlier case. The FIR of the earlier case. Yes, Lordship, 96 page 41 and 42, Lordship.
Yes. Yes. Charge sheet submitted.
Charge sheet has been submitted.
Victim call has been.
No, your lordship. On the previous day, she didn't choose to, she didn't come up before the trial. And the
Where have you have stated that?
lordship, it is in the. It is on page.
How long you are in custody?
We got almost for 4 months.
Council appearing on behalf of the petitioner. Submit that. The alleged incident occurred on May 3, 2020. Almost after a year, the mother of the victim lodged a complaint on April 27, 2023. On April 12, 2023. Thereafter, a charge sheet was filed on April 27, 2023. Next, he further submits that a similar complaint was lodged against the division in case filed at Matikara police station, and the petitioner has already obtained bail, not received, obtained bail in the said case.
He submits that the petitioner has been incarcerated in judicial custody since April 27, 2023. As such, since the charge sheet has been already filed, no useful purpose will be served by further incarceration of the petitioner. Next. Ms. Das, former learned counsel, appears on behalf of the state and submits that there are severe incriminatory documents against the petitioner. Furthermore, the petitioner is a habitual offender and the prayer for bail should be rejected on that ground. Next, considering the rival submissions of the parties and the materials placed on record, this court finds that the complaint has been lodged almost 1 year after the alleged incident was started. Furthermore, in the furthermore, after perusing the FIR and the statement made under 164 of the Code of Criminal Procedure, well, it is found that the delay in filing the said complaint has not been sufficiently explained by the de facto complainant. Next. In the aforesaid prospectus, this court finds that further incarceration of the petitioner in judicial custody may not be necessary. Therefore, it directs 10,000 surety.
Who is the satisfaction of?
Inspector in charge, pursuant to this patient.
It's on board
Inspector in charge. The petitioner shall meet the inspector in charge, Person Police Station once a week and once a week until further orders. Furthermore, the petitioner shall attend all the dates on which the court proceedings are scheduled to be held. That will not tamper with the witness and usual time. Complete disclosures.
Stable করে দাও। How long you're in custody?
I am in custody about more than 3 months.
Don't be so pitiful, Mr. Mehta. 3 months, my lord. No, we understand your anxiety. Understand. If we had been there, same thing would have. Yes.
The written complaint specifically stated that victim of suffered physically.
Suffered physical. What is her age?
4 years.
4 years.
Around the 160.
Ajita, 4 years. Yes, Mr.
My specific contention that as it is the medical report, this totally false. I being the neighbor due to pressure of the defect of and there is a severe enemy for this all complaints are blocked by. Nothing was that, but I can't see it medical.
164 is there for the
That sheet is fine.
Yes, ma'am, that's it.
She has submitted on 24th of June 2023.
My case was fine. Externals and internals.
Well, 164 is the victim.
Yes,
We age 60 to. This petitioner name is there. There is no evidence of any previous enmity between the parties. No evidence. No evidence of previous.
yes.
May I submit?
Yes,
But
you speak to that.
during if the article question there is the charge sheet, charge sheet also stated that the investigating officer going to the fact of complainant house, wiring happens with the victim, stated that this was possible. Wiring happens not 100%.
Sir, what can happen 4 years?
I know, this is the bad case. I know, my thing is that my whether someone in a physical injury, whether it is corroborated by medical evidence, I don't know, I am not 207 copies not applied to me also, it is not.
4 years, daughter, what physical injury? How can she resist a person of more than 30 years?
I know, my lord. If you is the complaint stated that he suffered physical injury. In the complaint, I cannot. In the complaint, I cannot say. One. Well, 16 lives.
And the-
Relevant for it's about physical.
Yeah.
4 years innocent girl.
Wait, Mr. Chakraborty. He also-
Mr. Calcutta, Commander Council appears on behalf of the petitioner and submit that there is a long-standing enmity between the petitioner and the victim girl's family. The complaint lodged against the petitioner on May 30, 2023 is false, and the petitioner who has been incarcerated since
31st, when it will be-
May 31, 2020. Should be released on the. Next. Mr. CHAKRABORTY, Commandant Council appearing on behalf of the state service. That the victim girl is only 4 years of age. There is no previous enmity between the parties. The crime committed by the petitioner is heinous in nature, and therefore the prayer of bail should be rejected. Next. Considering the rival submissions of the parties and the materials based on report, this court finds that there is no previous enmity between the petitioner and the family of the victim girl. In fact, upon perusal of the FIR, it appears that there was a cordial relationship between the petitioner and the family of the victim girl. Due to such relationship, the father of the petitioner allowed the victim girl to go to the petitioner's house. Next, this court prima facie finds that the complaint that the crime alleged of is very serious in nature and therefore rejects the prayer of the.
Senior advocate Vinod Agarwal is here. He is out of station.
Who is your, which party state? You are,
Your Lordship, I am the petitioner.
you are?
NIA. I am not for senior advocate.
He is in custody. Why you should go to the next circuit? Do you have any problem? Do you oppose the prayer? Then we take it up. How long you are in custody?
2 years, 4 months, 4.5 months.
2
The
years.
charge has not come till the
We direct the court to frame the charges and expeditiously dispose of. Or you try your luck.
The condition of the trial court is that the judges of trial court is not appointed till the
Next circuit.
Your Lordship, I would like to not press.
You do not want to press it.
Yes.
You are not wanting to press why? Don't be afraid, madam. Do we have violent figures that you will be afraid of us?
Your Lordship, actually, I read.
You are the advocate on record. Are you the advocate on record?
Yes, Your Lordship.
So why do you want not to press this application?
Your Lordship, actually, as per my knowledge, this application will not maintainable in this case. That's why, Your Lordship, I would like to not press this.
Why not maintain?
Actually, in this matter, Mr. Vinod Agarwal, this.
Se to শুনেছি, we are wanting to know why she does not want to press.
Your Lordship, this is the matter of division bench, but this should go according to appeal court. In appeal court.
Is this bail in connection with the appeal? No.
Special Act, there is a provision, any kind of order against that appeal has appeal will lie before the
UAPA Act.
Section 21 of the NIA.
Section 29 of the NIA Act postulates, 21 of the NIA Act postulates an appeal. Any order from the
The coordinate bench had it on the earlier petition.
the coordinate bench rejected it on the ground of state.
No, not on the ground. Not on the ground of maintenance.
It was perhaps not present.
No, detailed order was passed.
Yes, sir.
It is under UAPA Act. It is under UAPA Act.
Yes. But the governing provisions are of the NIA.
Who is the advocate on record? You are there. On the prayer of the learned advocate appearing for the petitioner, the present application is dismissed as not reached.
Single prayer for the item.
Item number 18.
Yes.
Who is in 18? 18 same order. 18 type to list देखिए ना तो yes, there were 17.
Item was 17.
Item number 17, I am appealing for notice.
Around the petitioner come up with a bill application, we to post that it back in economy backing it will not be perfect.
So where is the order? Where are the repeated adjournment order?
Structural find is a full record.
Is not there.
I'll submit.
An adjournment has been preferred on behalf of the petitioner, the learned advocate appearing for CBI. No, NIA is present. Release the matter before the next. CBI, sorry, CBI. Yes, next.
One regarding. CPA and been certain people lordship that they been reported.
No, you take it back.
No, we have produced that we reported will take.
There is no order taking the CD on record. We don't find any order.
We have brought the CD. That was reported. CD was produced. That money is being.
Brought the CD to.
Yes, next.
Lordship, one interview. But just few minutes back, I received a very sad news that my paternal uncle has. Therefore, will be born.
Yes,
We leave the same place.
yes, what do you want?
And I'm saying that if on Monday, my lord.
Which one?
On Monday,
Huh.
any acknowledgement, maybe.
Your junior said there,
My
ask
juniors
them to
can
be-
accommodate, but maybe kind enough to know.
why your juniors will not be able to argue the matter.
No, whether they are completed with certain matters and.
All right, we shall remind us, we shall. Yes, next.
19.
Right.
Password. Who is your other side? You are there. Then who is we take it up after some time. What will be yours?
20. 28.
PM করে দাও দেখি 2 PM রেখে দাও কি হলো আইটেম নাম 2 PM
21.
you are appearing both you are appearing
22.
22. Yes, Mr. Poddar. Good case or bad case?
This also another.
Bad case. So we reject what can be done. Also special. Yes, Mr.
Petitioner is custody near about 300. But victim girl was with the mind.
What are the charges?
That is the FIR.
376D.
Lordship.
Any other person,
Lordship, 6 accused persons are there, Lordship.
they are in custody.
4 of them, they are absconding, Lordship, and 3 have been arrested by the police. Out of 6, 3 have been arrested.
4 and 3, 7. There were how many?
Lordship. Initially, Lordship, 3 accused persons are there. Initially, 2 were arrested. After that, another accused person was arrested, and 3 accused persons are absconding.
Oh, I see. So out of 3 arrested, he is one of them.
Lordship. Out of 6, 3 were arrested.
So was the 164 of the yes. Where is the medical?
It's Lordship. Medical page 25. Lordship, another page 93 is the report of the mental status of the victim, Lordship. Page 93. She is suffering from episode with psychotic symptoms. And Lordship, page 25 is the medical examination report.
In 93.
93 is the report of mental status of the victim girl.
Medical report and the FIR. Medical.
Medical.
Page 25 is the medical examination report.
Alright. Well, can you see it?
FIR.
Yeah. Major for medical evidence becomes conclusive by law. They are evidence.
No, why you are showing us the FIR? For what reason?
Nature thing as well as thing girl and the two boys fought by the engineer.
No, Lordship, there are 161 statements of the villagers, Lordship.
No, no, when they returned, they took the victim girl as well as those persons to the person who gave the girl, when it came to return the girl. He was intercepted, he was taken to the police station.
Lordship, the villagers called Rashidul and
Gopal Das.
Gopal Das, Lordship. 4 accused persons fled.
But can it be medical whether corroborated?
Yes.
Absolutely.
Mr. Shah put that form. Learned counsel appearing on behalf of the petitioner submits that the petitioner is in Calcutta for almost 1 minute. The allegations contained in the FIR are fabricated, and there is no correlation between the medical report and the allegations made in the FIR by the mother of the victim girl.
Lordship.
Next, Ms. Raj Kamal, counsel appearing on behalf of the state, submits that the allegations complained of in the FIR, the allegations made in the FIR here point towards a heinous crime against a minor, victim girl. She draws the attention of the court to the medical report and also the psychiatric report of the victim girl. Next. Considering the rival submission of the parties and the materials based on the report, this court finds that the victim girl was a minor of 14 years of age. Next, she was suffering from inverted commas manic episode with psychotic symptoms. Inverted commas. Furthermore, the medical report also corroborates the allegations made in the FIR. In such circumstances, this court is not willing to allow the prayer for bail. Consequently, the application for bail is rejected. Satisfied is.
My lord, 23, I'm for the petitioner, my lord. I'm appearing online. Am I audible to my lords?
Yes.
I'm obliged. My lord, one of its kind,
Yeah, just.
my lord, where the
The state, Mr. Chakraborty. You're there.
No, Lordship, CD is yet to be received, Lordship.
my lord, this is the 4th occasion, my lord. It was initially filed and it was adjourned in July, my lord. initially. This is the fourth occasion they are saying the CD is not here.
Later on, lordship will return the city lordship. Can it be
You
fixed on bundle?
on the last occasion, adjournment was made on your behalf, Mr. Bhattacharjee. And
No,
prior,
but since CD was not there, my lord. My
no,
lord,
no,
Monday matter was taken up, my lord. It was
Yes.
time was taken since CD was not there, my lord. My
Lordship,
junior was there, my lord. And since the previous order, my lord, by the bench, my lord, presided over by Justice Bhattacharya, my lord. And prior to that, your lordship will have, my lord, the order of the bench, my lord, presided over by my lord, Justice Bhattacharya.
Either sir, it's a prosecution.
yes, why it is not copied?
lordship, we have returned the CD already, lordship. Can it be fixed on Monday, lordship? Will do the.
Monday, we have many matters.
Petitioner के साथ तो भी
All right, Monday.
Great.
You arrange for this,
Lord.
otherwise we proceed.
I will not.
24.
Diplomat.
But I am praying for not to the matter because in this case, charge sheet has been submitted, but that charge sheet copy is not with me. I have applied for the charge sheet copy, my lord. It come, my lord, I will. Case of 302 charge sheet. After I will not.
What do you want? Next circuit,
No, no. We'll or Monday.
Monday now. Monday,
25.
It's my first time.
6th,
26.
26, you are there, Mr.
Commercial quantity earlier received lordship, direction for lordship experience time.
It's 89 bottles. 89 bottles, cover 11 bottles. How much will it cost?
There are 2 persons, you have recovery from you solely,
Both.
huh?
Both.
2 persons.
Yes.
Similar order করা হয়েছে তোমার hardly learned advocates appearing for the respective parties. It appears there was recovery of contraband substance above commercial quantity from the petitioner and another co-accused person. And as such, the statutory restrictions are clearly attracted. তারপর the petitioner, however, prays we একটা প্যারা আছে দিয়ে দিও না এটা লিখে দাও Mr. Rai, an advocate. Mr. Rai, an advocate appearing for the petitioner, has expressed his anguish and inconvenience, as regards the delay in progress of trial. Stop. We take notice of such issue and direct the learned court below to expeditiously conduct the trial and, if necessary, upon resorting to steps available under section 309 of the Code of Criminal Procedure, so that logical conclusion of the case may be reached at the earliest. And which were clearly attracted. As such, the petitioner's prayer for bail is rejected at this stage. Application dismissed.
27.
Short one.
Passover.
28.
It's similar.
Against the CD. 28.
Yes, 28.
City not put the pilot next.
No, 28 was serious, not.
Why you are not?
My lord, kindly fix it on one day. You can-
Monday the morning, you love her son. বুধবার Wednesday. Wednesday.
Yes. Twenty-nine.
Next Wednesday.
30.
So in this case, nothing.
সুজন থার্টিটা কি
In this case, two parties were arrested and found their position intermediate quantity of whatever article. And their statement, this petitioner was arrested and found the position of this petitioner, all the intermediate quantity of contraband article was required. This petitioner was granted a pardon of 21st December 2020. 21st December 2022. Below commercial quantity of contraband covered from the position of this petitioner.
where is you have annexed the Caesar list.
Yes, page number 17.
So why did you withdraw in the month of July? Your earlier application,
Yes, Nasir, withdraws.
why? Where is your charge sheet submitted? Where is the? Your name is?
Because.
Because they were other co-accused also.
Now, in this case, two accused Chigme Vanchuk Putia and Rajesh Guru were arrested, and from one of the leading statement, this Vishal Verma was arrested, and from him 10 bottles of hospital.
That was intermediate. So.
Mr. Roy, the council appearing on behalf of the petitioner. Submits that the petitioner was arrested on December 20, on the statement of overseas. The content are recovered from the content article allegedly recovered from the division was below the commercial quantity. It was of intermediate quantity. First off. The content submits that the charge sheet was submitted on March 31, 2020. And as such, used to purpose with services served by further incarceration of the appearing on behalf of the state opposes such bill. He submits that there are several legally documents against the petition. Considering the diverse submission to the parties and the materials placed for this court is of the view that the articles which were allegedly recovered from the possession of the petition was word of intermediate quantity, and as such, the rigors of section 37 of the NDPS Act are not attractive. Full stop. Next. Also found this court finds that the charge sheet has already been filed on March 31, 2020. Therefore, let's sign such reading list on the 10,000. And we meet the once a week should have been.
That all dates.
Yes.
And first state of
Which police station?
Kalimpong
Kalimpong.
police station. Officer in charge from a Kalimpong police station once a week and shall attend all hearings. At the before the additional district and sessions judge within bracket NDPS and bracket closed, Kalimpong police station.
And Mr. Roy Ragged, expeditious disposal. With the rejected one, with the refused at this stage. Mr. Chocolate is that for that. That expeditious trial. We have rejected, we are saying refused at this stage. Yes. Refused at this stage. Our application the last day disposed of. Yes, please.
31. Not is what wow.
Password you call for.
Item number 10, password.
grants bail to the petitioner. The appointment director, 10,000. Two sureties to the satisfaction of the special judge from special in the case. Additional second judge. Second court for civil. Yes. The petitioner shall also make himself available on all the dates of the trial. And is required not to leave the jurisdiction of the concerned police station without the leave of the authorities. The petitioner shall not induce the defense or increase the remaining act or tap for the benefits. Such and such according to the
Capital A that's not applicable nothing is nothing. So for other system punishment is better habeas magistrate tribunal years
46A is how many years?
10 years.
What was the recovery from you?
Recovery worksheet. More plastic, the total of was 568, total of 93, total of rectified 3 and 1 jar of rectified.
Then why you are saying 46A not applicable?
In case of one there is the
46AA.
capital double.
How long you are in custody?
That is the particular 21st April 2020.
And she submitted.
No, you are submitted. You are not submitted, sir. You are submitted. You are the popular thing. So the street. If you are not submitted, the secretary will follow what order.
Yes, Mr. Chauku.
Sorry. But I didn't get the prosecution offense report in the CD document. You are not submitted like it. The secretary will follow work for 10 years. How is the seat? It is secretary like be there. But it's still double. And a chemical exemption report has come in case number 43, the human consumption. Taking nature.
So you take the information with the prosecution report filed.
Does it submitted nothing? Otherwise, I guess secretary will come.
No, if it is live, it is not 60 days. No?
90 days of it.
Yes,
but more than 4 months, I mean, trust it.
plus for excise act. Any antecedent?
No, Your Worship. From the huge land to attitude.
Where you are deciding?
82, sir, Central Working. Regulation, magistrate having jurisdiction to try the offences. All the offences are magistrate trial, Your Worship.
46A is there.
Yes, Your Worship. Yes, sir. Magistrate trial, but there is no stance of a custodial trial.
46A is magistrate trial.
Yes, Your Worship. Yes, section 82, Your Worship.
Mr. John, kindly come to the order of 10th August 23, which he has annexed. There it is, PUR is submitted.
But in my.
No, kindly come to that page.
I want to get into this. CD. We put your mind.
No, not that. His petition.
Yes.
Do you have his petition?
Yes.
Come to the order which he has annexed. First, second, third, fourth, fifth, sixth paragraph. It appears the case has been in 46A along with others has seen the season this PUR and chemical exam.
Yes, you might. From what I think, but the state intent does not. Yes. Once a week. Mr. Radho, learned counsel appearing on behalf of the petitioner submits that the offensive complaint in the FIA are all magistrate trial offenses apart from 46.
Submission of sufficient. Now, 46A who mentioned. 46A is also mentioned.
They are all magistrate trial offences under the Bengal Excise Act. Apart from the Bengal Excise Act. He submits that the petitioner has been falsely implicated and since he is suffering incarceration, since when is he incarcerated?
21st April 2020.
Since April 21, 2023. No, further useful progress will be served by retaining him in custody. Finally,
Mr.
Mr. Sharkar, Commander and Council appeared on behalf of state and submits that there are several incriminating documents against the petition, and therefore the prayer for bail should be. Considering the rival submissions of the parties and the materials based on it, this court finds that this court primarily finds that the offense under section 46AA. The 46AA of the 1909 Act relates to penalty for occurrence of death due to consumption of liquor. Next, this court also finds that the PO1 within bracket prosecution bracket has already
What is the full form? POR?
prosecution offense has already been filed before the learned parliament. According to law, no useful purpose may be served by further incarceration of the petition. Next. Therefore, petition shall be released on bail. 10,000 insurance one local shall meet the officer in charge of excise. The officer in charge of excise.
Who is your, which officer is the?
No, officer in charge excise. Hon'ble Circle, Jalpaiguri, 1 week. It has to be furnished to the satisfaction.
Satisfaction of?
Chief Judicial Magistrate, Jalpaiguri, and also shall attend all the dates of hearing. All the scheduled dates of hearing.
Yes.
According to these items, is
27.
NDPS. NDPS.
Yes, sir. Two fundamental articles report from the original.
Is it so, Mr. Sarkar? বলছে যে below commercial, no, nothing recovered from you. Do we keep it at 2 o'clock? Will you try? 2 p.m.
31. No.
Lordships, in that case, yesterday, I put a heart.
Yes, yes, scooter.
Yes, your lordships, is we consider that the coordinate way to the particular case of granted being a lordship. Lordship might come from
Similar case.
similar type of allegations made against the one scooter and the person who was riding near the scooter and some recovery was made and subsequently on the basis of the confessional statement, some recovery was made from the house. This more than prevents this petition as is concerned, your lordship. Lordship, from the FIR itself, there is a discrimination regarding the authenticity of the serial. Not only that, the owner of the scooty has not been made a party or charge has already been filed, your lordship. Considering that aspect, no recovery was made from the exclusive position of this petition. It was recovered from the DK. Where this petitioner was standing near a Babupara. Babupara is a busy road of Siliguri. And in front of the pawn shop, he was there. And these police arrived there with two witnesses and recovered some articles from the DK of the same scooter. And the scooter, who is the owner of the scooter? And till now, charge sheet has been filed, your lordship. The scooty ownership has not been ascertained whether who is the owner. This petitioner is not the owner of that scooty. And no exclusive recovered was from the person of this petitioner, your lordship. Charge sheet has been filed 278 days in custody. No exclusive and conscious position, your lordship. As the charge sheet is filed, your lordship, from the FIR, your lordship will be filed now.
We along with the independent witnesses that I had subsequently the appointed of the electrons, but not standing there. And I'm seeing it right to freedom. From this spot, right in this. He tried to flee away from his road riding. What did you say?
My lord directs me to file a report whether there is any antecedents or not, and whether this scooty belongs to him or not, my lord. The IO already mailed me, but it's load shedding. I can't get the copies. My lord, there is no antecedents, and
No, we are-
belongs to one Piyush Sethia.
So have you intercepted him?
No, Piyush, no.
So unless you get hold of him, he is the person to say whether he has any relationship with this.
This petitioner bought that scooty from Meru Shetia in the year 2021. But
Bought
the
it?
ownership, yes, but the ownership not transferred.
So how did you find, is there any documentation that he brought, that is not in your chart sheet also, forwarding report?
Initially, like, lab of the vehicles, I don't know to change.
It's not. This is the name of.
Use have not been inaugurated.
And what it is. Has already been started with the.
In chart sheet, Pijus is not there.
No. So my connection of this scooty can be established from the second of.
Power put together. You are appearing. All right, 2 PM you bring that email.
I will. Because of road shedding, I'm not. But they WhatsApp me.
Yes,
And
read it, what is there?
I thoroughly interrogated the arrested accused person named Shudon alias Dean, and after prolonged interrogation, he revealed that he is involved in procuring and selling of injection. Further, he stated that the registered owner of the scooty, Piyush Shetty, he purchased the scooty along with its relevant documents from Piyush Shetty on 2021, but could not complete the process of transferring of ownership of scooty due to prevailing pandemic. Was this one?
That is the statement of the administration by the.
Sir, will you keep quiet? We are applying our mind. Is there any other co-accused? No.
No, this is so late.
In your forwarding report, once you say that he tried to flee away riding the scooter.
Yes.
Once you say he was near the scooter.
Yes, sir.
And next you say it was conscious possession of the person.
It is fact.
Three different discrepancies.
It is fact. I have gone through the FIR.
What was the recovery? Two commodity below contraband.
One item, commercial quantity.
Which is that item?
Blueprint of North. Blueprint of
That's blueprint, that is lipid. This is commercial.
Yes, and other diazepam is
Diazepam was intermediate.
intermediate, and another does not occur indicates.
Not in schedule.
No.
So this is above. What is the commercial quantity?
20.
20.
Yes.
And it was, he got 200.
200.
2 ampule, 100 amperes of 2 each.
Out of the street. After intermediary diet from.
Diazepam intermediate. 500.
NDPS not action.
Learned counsel appearing on behalf of the petition. Submits that the petitioner is not in any way connected with the offense complained of in the first information report within bracket FIR. The petitioner has been falsely implicated as he was only standing near the scooter from which the Complement articles were recovered. So, furthermore, the petitioner has no antecedents, no criminal antecedents. Next. Learned counsel appearing on behalf of the state submits that the scooter from which the complement articles were obtained belongs to one Sethia.
You said.
One Piyush Sethia. Full stop. However, the said Piyush Sethia had transferred the said vehicle to the petitioner, even though the name of the petitioner does not appear as the recorded owner in the documents. However, there is a direct nexus between the petitioner and the offense complained of. In such view of the matter, the bail application of the petitioner should be rejected. Next one, select the rival submissions of the parties and the materials placed on record. This finds that out of the 3 articles recovered from the scooter, only one article is one complement article is above commercial quantity. The second article is of intermediate quantity, and the third article does not attract the provisions of the NDPS action. Furthermore, furthermore, on basis of the contents of the charge, it appears that there are several discrepancies. Furthermore, the petitioner has no antecedents. Therefore, this court is inclined to grant bail to the petitioner. The petitioner on the following conditions. What the conditions to be the petitioner shall not the jurisdiction of Siliguri police station. The petitioner shall also attend all the evidence will meet once a week.
Where do you stay?
All the dates of hearing before the judge, special NDPS Act. I would usually be the which cannot tamper with the evidence.
Satisfaction of the concerned judge. Who is satisfaction of? You will not leave Siliguri.
Special the NDPS similar case. Passed in CRN within bracket 10 years bracket. History of 2023 was passed by.
Thank you. You would choose. Submission of the petition. It must be last. Yes, confidence. I give his name. Which your other side? Oh, you have brought it.
Yes, sir.
Show it to me. Twice.
Civil years, I have been targeted murder, or kindly know the conditions. Annex the documents of.
Mr. Charge sheet submitted.
Not that.
Huh?
Not party.
Charge sheet not submitted. It was 6th of July.
Bill was drafted. And all the outside, they have a time. But
Twice.
It was passed on 6th July. Investigation is also not over. And the court, being conscious of your condition, has said twice daily.
I complied with the order. feel that Margaret has complied with the order. My submission is that the petitioner is hard question, but I analyze the order, Margaret. And but. And what he is a.
This was also there at the time the order was passed. It was 10th of December, 10th of February. That is prior to the order. This was considered, Mr. Guru. Wait for some days. Wait, what is the charge sheet has been filed?
No,
So what is the stage? What you are investigating officer? Have you taken information?
no, I have to. You need information. But the condition is more hard. You will with the investigating officer twice daily. I consider this aspect. I mean, it is about 67 years old. Hard patient manner. Twice a daily manner. But these not a such offense manner, this case manner. You will meet the investigating officer twice.
Yes, what do you say? When charge sheet has not been filed, then the police must be, we do not know how many whose persons are there, what.
No, no, no.
Yes.
In this case, he is always the one who had to stole every corner. Out of political strategy, this case has started. I am the
Since July, we are not even a month, no, just 1.5 months have passed.
But I give you one scenario. But at the time of doing content election, Margaret, this. Due to the concept election, this condition was not imposed. As because I am a political person and concept election is going on, I am not doing any creating any nuisance for that reason. Condition or now concept election is over.
This medical, that is not a ground in your terms.
But I am saying for more. I am saying, but I am a hard patient.
Your heart patient disease was there when the order was passed, not a single medical document subsequent there. It creates suspicion, Mr.
But this case,
It creates suspicion.
Daily it is the.
Exactly that.
It is.
Where now,
I will comply all the other, all the condition till the from 1.5 months. I never receive the liberty. I am the resident of permanent resident of that place. I am not absconding. I am the ex contract of that locality.
that is the problem.
But that is the problem. But now election is over, everything is over. Once in a week,
Mr. Guhul and the advocate heading for the petitioner submits that the petitioner has complied with the conditions of bail as specified in the order dated 6th of July 2023 and has met with the officer in charge, met with the investigating officer twice daily as directed. At the service that the petitioner is a heart patient in support of such contention. What is this? Khana Hajira
yes, yes.
in support of such contention. We will say, Mr. We will say that he has substantially complied.
In some of such condition.
What are they?
It's almost an impossible condition. The man has just been in this task.
Mr. Vishwas started advocate appearing in the state. Learned advocate appearing for the state submits that there is no adverse report. Adverse submits that there is no adverse report against the petitioner. Upon here, however, he submits that investigation is still ongoing. Upon hearing the learned advocates, the condition to meet the investigating officer twice till submission of the charge sheet is modified to the effect that the petitioner shall meet with the investigating officer twice in a week till the investigation is completed. Stopping the above observations, the application being happy is disposed.
Twice only.
In support of such contention, he has drawn our attention to the attendance record. The yes. Application disposal.
33. For the appeal. 11 July 22, there was a direction to file the affidavit in opposition.
You are for the appellant.
Yes. So internally, I received the opposition. I appeal for the Siliguri municipal corporation.
You are appealing for
Siliguri municipal corporation. There is an order passed by the division bench of this project on 11 July 2023. Opposition remains.
you preferred this is double PST.
Being agreed by the order, we are filing this application for 11 July 2022. Order was passed by the division bench. Electing and executing opposition.
Why it is given special leave petition civil? Petition under 136 from you preferred appeal, SLP. Shekhar Chaudhary. Shekhar Chaudhary is the respect.
In the appeal. I am both of the.
You are both of it of the look into this document. No.
Maybe in terms of the last order, the private hospital here came out and actually because one of the Supreme Court has dismissed the.
That is, you do not know about this.
No, officer not.
Then who appears for Shekhar Chaudhary?
Mr. Sanjay.
Where is he? You are for whom?
Siliguri municipal corporation.
So where is that person? Where is the advocate? We don't know what the Supreme Court has observed in that order. How can we extend the time? It was dismissed, but what is the observation? We do not know. He must tell us. He is appearing for Shekhar.
Now this.
One application opposition and one can application for bracketing. Now these two applications.
You were appearing for Gautam Das.
Now what has happened is that Shiva Chaudhary, you are trying to set up an expert. And he has applied for permission from legal expert for water connection. The water connection, subsequent to the order filed by this honorable High Court, single water connection was given to the ice factory. Now, they have come up in appeal before this honorable division bench, stating that he does not have required licenses under the existing laws.
That we know.
Yes,
That we
that
know.
was.
Now, what are those two applications?
Essentially, we don't have license.
Read petition. So it are against the appeal by the person. They are not pursuing. So these two applications have been filed by Gautam Das,
No, madam, by Shepherd.
by Shekhar.
Yes, ma'am.
Appeal is filed by Gautam Das.
In connection with that, they have filed two applications. What are those applications?
But we don't have any, I don't say.
So if you don't have, how you will file opposition?
That's it, but day before yesterday, he has filed the opposition.
Opposition to what? To your stay application.
Yes.
The order passed by 11, by the lordship on 11 September 2022.
So, Rishwa, we didn't grant
Who is the advocate for him? Shekhar is your friend. He appears here.
Yes.
Have you found him today? Yes, we. You are Miss Muthu learned advocate. Muthu learned advocate appearing for the appellate submits that she has been served a copy of an affidavit in opposition to the stay application.
That is now in application for vacating the application.
So if it is their application,
One opposition they are filed. And matter.
vacating application was filed by the respondent.
Yes.
What is the number of that? Why you are saying opposition? Now you want to, they have filed an application, you find to file an opposition.
And they have also filed an opposition.
State Guru can do. State Guru can do it.
After that, he has filed a scan application, can fee.
We are not concerned with the CAN. They have filed an opposition to the
Please
stay
tell me
application.
your opposition. What opposition did you get? ক্যান নাম্বারটা ক্যান 3 ক্যান 3 টা ফাইল করেছে সেটা তো আলাদা
পজিশনটা ফাইল করে কিন্তু একটা
ম্যাটার এগেইনস্ট স্টেট পিটিশনেরই তো অপোজিশনটা দেবে ও অ্যাপিলটা দেখুন মেমোরেন্ডাম অফ ক্যান নাম্বারটা মেনশন করেনি ক্যান নাম্বারটা কোন ক্যান
Can can
Madam,
ক্যান 3 অপোজিশন করে ফাইল করবে ক্যান 3 টা কোডে
either you know the facts nor the petitioner is appearing and we are at a loss.
এটা ক্যান 3 ফাইল করেছে ক্যান 3 টা তো ওকে দিয়েছে
আর এটাই লিস্টে আছে
আর অ্যাপ্লিকেশন অপারেশনটা ফাইল
তাহলে আজকে তো কেন আসেনি কেন আমরা তো আমাকে ডিসকাস করতে না
না না স্টে অ্যাপ্লিকেশন
ও না না ক্যান 1 and 2 রিসলভ
ক্যান 1 এর ডিসপোজ করতে
ক্যান সিটেড
ক্যান 3 টা রেসপন্ডেন্ট ফাইল করেছে মানে রিপিটিশন না রিপিটিশনাল ফাইল করেছে ক্যান what stay of this application passed by a board member
our stay of the state
There is stay of the order passed by the board member the vacating was stage vacating stage
vacating the operation of the order.
and this is their application the requisition of the application can be and you have this is your opposition that whose opposition it will be the respondent because can 1 and 2 are already disposed of opposition to what this application opposition has been filed to what
There was a direction to file the opposition.
Are what opposition 1 and 2 applications were there both were disposed of.
the age এইটা কিন্তু এখানে
Dispose of করে দিয়ে
disposal of foreign opposition file করে দিচ্ছে এবারে এগুলো ডিসপোজ করে কেন ক্যান নাম্বার কি লিখে and the repetitioner the applicant in can and stroke repetition no one appears in the application being can 3 of 2023. Full stop. The said application has been filed by the respondent number 1 in the appeal stroke the repetition. Yes. Ms. Rudra, Commandant Council appears on behalf of the appellant. She pays for time to file an affidavit in opposition to can 3 of 2023. Such prayer is considered an account. According to next. How long will you require? 2 weeks for let the affidavit in opposition be filed within 2 weeks from the start. Within 2 weeks thereafter. Parties will get liberty to mention them for hearing before the available circuit. So.
34.
My lord, I am for the appealant. Am I audible, my lord? Am I audible, my lord?
I am for the respondent.
Am I audible, my lord?
Yes, yes.
I am for the appealant, West Bengal State Election Commission, my lord. I prefer this appeal against the order that is dated 14 August 2023. The order is at page 46 of the stay application, my lord.
Not appearing, Mr. Roy.
I am for the West Bengal State Election Commission, my lord.
Well, before, Mr. Ray starts,
Yes.
So it's my appeal. Your lordship kindly come. The improved order is at page 46.
Yes. What
At
happened on 24th?
Yes, my lord.
What
14
happened
August.
on 24th?
My lord, I do not. Sorry, my lord. I do not.
And how many people will apply that? One is appearing virtual, one is appearing here in person.
I am for the appealant.
I do not understand.
So your lordship kindly, there's 10 matters, the analogous orders. The improved order is at page 46 of the stay application. This is item number 34, my lord. This is Jagadish Sarkar.
because if your lordship kindly allow me for a moment, but I'll just clarify this.
Just go, let us go.
No, my lord, kindly allow me. Lordship will take up item number 38. Why I'm telling this, my lord?
That was the order passed in the first application.
Yes, there are 10 writ petitions filed, my lord.
Hmm.
Finally, order was passed in one writ petition, which the appeal is before your lordship at serial number 38.
Hmm.
The rest of the writ petitions, my lord, were adjourned for 6 weeks.
Rest of the writ petitions were?
Were adjourned for 6 weeks on 24th of August. So if your lordship kindly takes up serial number 38, that is the writ petition, my lord, where the order was passed.
Your lordship can appreciate what happened. If my language is correct. These 10 analogous matters. Then 10 analogous matters, the order was passed for production of the CCTV footage of counting center, polling center, and the strong room. But when the subsequently item 38 was heard by his lordship Justice Calcutta, and he passed certain orders. And then, my lord, other matters remain, my lord, kept in pending. But here this is the improved order. The basic in all the matters, the basic order is we have challenged whether it is a writ lies or not. This is my main basic point, my lord. So here, if this matter be heard, all the matters be covered. So here the fundamental question whether it is a writ petition is maintainable or it is an election petition. This is the point. So I just place the judgment page 46. This is a fundamental orders passed in all the matters.
Yeah, just a moment. So Mr. Roy, the crux of the matter is that whether it is an election petition or not.
Yes, yes, yes.
If it is not an election petition, then the court cannot continue to be in session of the same.
Yes, yes.
This is your argument.
This is my argument.
So
They are pretty-
filed any stay, have you filed any application in connection with
Yes,
the,
yes, yes. This is appearing to lordship.
you file your opposition, we hear
And
it.
my lord, I have a point of maintainability, my lord, we can, if you-
Maintainability is what we will hear.
No, maintainability of the instant appeal, my.
Why?
My lord will kindly see the impugned order.
We have seen the
Yes.
impugned order.
The State Election Commission, in spite of service, chose not to appear before the review.
Very
And also, my lord chose not to take up the maintainability point there when the matter was heard. Now, in the, either in the memorandum of appeal
Hmm.
or in the stay application,
You see prayer A of the writ petition.
we have not stressed that,
What you have not pressed.
the prayer A.
Where that is not recorded in
That
the
has
order.
not been recorded, but it was submitted that you are
So
not.
that is because when the court was going on the basis of the prayer B, you did not, you kept quiet.
My amendments,
So now he will take the point. Prayer A is repolling of the, so repolling whether it comes within the election dispute or not, that is what he will argue.
yes.
So show us the line where you have not pressed. Then you withdraw.
That will not be rejected.
Mr. Vatajaji, if that is not
Yes,
reflected, so good, bad, indifferent, Mr. Roy will not, Mr. Roy will argue on that. We cannot stop him from arguing on that point. But what is your point of maintainability? Your point of maintainability is they appeared, they did not say that it is an election dispute.
Yes, the point that.
Are what they will say, the learned single judge himself said that it is not an election dispute. I only want to see the CDR records, and if it is found all right, I will dismiss the petition. And if it is not found all right, I will interpret. Now the court has been, writ petition has been kept part before his lordship. So we cannot take up the writ petition along with the appellant here. So it is for you now to, for Mr. Roy to take appropriate steps.
Because the point of maintainability was raised by the state.
Point of maintenance.
Maintainability of the repetition was.
No, Mr. Vatajaji, kindly appreciate. The writ petition was filed with multiple prayers.
Not.
First prayer was, why do you want repolling? You want repolling because according to you, there were disturbances which were recorded by the CCTV. This is your case. So section 79 of the Panchayat Election Act, it says in which circumstances you can come. And you go to the West Bengal Election Commission Act of 1994 under section 92 or 93 that if there is a corrupt practice, still it will be a election petition.
93.
So if it is a corrupt practice, it will be an election petition. He will argue that.
Then let us come back with our affidavits.
Are we right, Mr. Roy? That will be.
This is my argument. This is election, my lord, my point is that, so your lordship, this is the first time I'm not argue. This is my point.
Mr. Roy, as a the court we are ordering, why you are reluctant to face this CCTV coverage material?
But this is not the issue. Issue is that, my lord, I'm for the election commission. Our principle, our guideline is, my lord, what happened in this, suppose in this matter it is not allowed. That was the main, these are fundamental points. There is the constitutional fundamental points. You say, oh, this is a election dispute or not. Unless, my lord, for one instance, it may occur, but it will be the precedent. This is the main, my lord, anxiety of the election commission. Election commission's submission is that whether this pleadings shows anywhere that it is not election petition. You must only see their pleadings at page 25, my lord, for a moment. So you also said, this is my argument. Section 74 covers.
Judgment which you are relying, Mr. Roy, of the Supreme Court,
Yes.
2018.
Yes.
That judgment, subject to correction, whatever you argue, that is relating to application of IT Act in the,
Yes, yes, ma'am.
Yes. that will not.
There's other judgments. You must kindly fix on Monday. Kindly fix it Monday. I've just showed other judgments. But I could not come today. Kindly take it Monday. I'll place all the judgments.
Yes,
Can you fix on Monday, my lord? I'll
no,
come.
let him come with opposition, what Monday?
My
I
lord,
think
my lord,
6
kindly
weeks at-
pass the order, with respect to, serial number 38. Rest will get covered then.
All of them.
No, we will pass the same order in
In respect of all. Great.
38 the days.
Well, 38 if your lordship do not.
You are appearing,
I will put the state lordship.
you are.
Is the additional advocacy
The
here?
preliminary point which I have raised before the current lead court. No, it will prefer the state. And I am not preferred as state, appeal. The election commission has preferred appeal. Now, if your lordship see the entire, the submission which is recorded in the first order. I have raised the serious objection with regards to 243 O and B of the article of the Constitution of India.
243 O electoral matter barred.
Yes.
243 O is electoral matters outside the jurisdiction.
B is particularly the concept election.
Court is exercising read jurisdiction, sir, 226.
That I am saying, that is the objection which I have raised.
How can you take the court can reach wherever there is injustice?
But lordship kindly.
Wherever there is injustice.
Lordship kindly see, which suppose now, even the court intends to see the CCTV footages on the basis of a malpractice which may raise in lead petition.
Yeah.
Which has been demonstrated.
Right.
Suppose now, even technically, if we see that here there is a malpractice seen by the court.
Yes, then we will raise an election dispute.
Then we also dispute, now what will happen? Now they will collect the evidence,
Who will collect?
the petitioner, suppose now.
The petitioner is not in
Please,
control of that material. It is CCTV installed by you.
Yes.
So what they will collect? Judge will see it.
Judge-
Video has filed it in a sealed
They
doc.
can open court, judge will see.
Judge himself went to the place. That was his observation.
So lordship kindly see, went to the place in front of all people,
This is.
all the.
Try to appreciate the case has two limbs.
Yes.
One is the judge, single judge says that it is not an election dispute. And I only want to see the CCTV footage. This is the dispute. Mr. Roy says that direction could not have been issued because the writ petition is not maintainable itself, because it is an election dispute.
That is also my stand.
We will consider that.
That is so my view that with regards to 38.
38.
Huh?
38.
Lordship, with regards to 38,
Hmm.
unless the order is stayed, because the matter has been cleared as a part in half. And the. I am objecting to this prayer of stay, because this appeal has not been prepared by the state.
Yes.
This appeal has not been prepared by the state.
Yes.
There's a proforma respondent.
Sorry, I missed your sentence.
Totally.
You are appearing for state.
Yes.
See, he's the additional advocate general, my lord. He's the additional.
Yes, I
advocate.
forgot
Yes,
his sentence.
But you also can appreciate unless there is stay. And if the single judge. My
So
lord,
the opposition, you will file it within how many?
2 weeks.
Make it
4
a week.
weeks.
Make it a week, madam. I will file it within.
You will file it within a week. Let the point, because the matter has been adjourned for 6 weeks. So it will appear before the single judge. Prior to that, this point has to be.
Yes,
resolved.
yes, within a week. Yes, within a week.
A reply to. 3 days.
Mr. Roy Kumar, learned counsel appearing on behalf of the election commission, challenging election commission's appellant challenges the maintenance of the writ petition on the ground that an election petition was required to be filed. Required to be filed for agitating the issues raised in WPA 1805 of 2023. He draws the attention of this court to the prayers made in the repetition in support of his contention.
Madam, microphone টা চলছে কি?
In
শুনতে
support
পারবেন?
of his
Yes,
contention
I am hearing one.
that
I'm listening.
the repetition is not maintained. Next. Mr. Chaudhary, Commander, the Additional Advocate General, also supports such stand of the election division. Appearing for this statement. Mr. Bhattacharya, Commander, with counsel appearing for the petitioner's group respondent. Place for time. To file an affidavit in opposition to the state petition being Dan 1 of 2023. Such prayer is considered an allowed. Later, an affidavit in opposition will be filed by 1 week from date. Reply if it
3 days, my lord. I'll file it on 3 days.
by 3 days thereafter. Let the matter appear.
Mr. Chaudhary, you also file within 3 days then.
If they want, they might.
He must say he supports me. So
This is
Let the matter.
in absence of any argument.
Circuit bench, Mr. Sir.
Two weeks.
all matters, my lord.
Matter will appear 2 weeks
After
this period is over.
You mentioned
34 to 43, my lord. They want 34 to
All the
43.
matters was same order.
34 to 43. I no longer identical orders.
আচ্ছা এই সেম অর্ডার হয়ে যাবে ফ্রম আইটেম নাম্বার
34.
Go to 43, my lord.
তুমি আগে 30 যেটা ম্যাডাম
38.
38 এটা প্রিন্ট আউট বেট করে রাখতে এটা একটু হয়ে যাবে actually
And liberty be granted to ask for the stay, my lord. With your lordship, my lord.
we have not said that we only called for the
Sorry,
natural.
my lord, it is not hard, my lord. Kindly liberty be granted, my lord.
No, what liberty, Mr. Roy, you are there to go for that along with Mr. Chaudhary.
But if any goal with them, considering.
Yes, Mr. Chaudhary. শুনতে পাচ্ছে? Yes, Mr. Chaudhary.
তুই আছিস সবাই এপিক আগে জুনিয়র কিছু করে দিলে আমার আজকে পুজো ভাবনা হবে হওয়ার ভয় অবস্থা একবার শুনবেন
Stage one, that matter is going to take today. I come from Calcutta and that matter is from.
Which matter?
Item number 14, code number 111.
Who is your other side?
My lordship, state of West Bengal.
No, which advocate is appearing?
My lordship, it is in-person matter.
No, who is your advocate in the other side?
My lordship,
Do you know?
no, my lordship. That is. My lordship, learned advocate here one become a few was at in my lordship, I didn't know exactly.
I cannot assure you, but we shall try to seek. If it gets early, I will sit. I cannot assure you. You have any problem today?
My lordship, not any problem, but I come from Calcutta and that matter is my father's matter. He executed a power of attorney in favor of myself and his daughter.
You take the assistance of the lawyers. Who are your other side? Who is the advocate of the state? Please ascertain. Wait for some time. Let us see if it is over. We will try. Yes, next.
Item number 3.
Yes. Three. Who is your other? Three. Yes, yes. Anticipated. Six. Fifth. Please bring the CD on. Yes, next.
Item number 4.
No CD. Fifth.
Item number 6.
You have the CD.
Yes.
Yes.
It's relating to abandonment suicide along with 498A. Petitioner before your lordship is a husband. Lordship time comes to the list of dates. Starts after the presentation. You can see the date, the list of lordship has found. So the date of incident, kindly see when she has committed suicide. 21st of April 2022. 156 clause 3 has been filed and subsequently FIR has been registered 1 year thereafter. Can you see the date? 13th of April 2023. There are 8 family members. 1 is before your lordship. Other 7 have been granted anticipatory by the learned court below.
He's the husband.
My lord.
This person.
I am the husband, not the principal. Here I get because the allegation made in the 156.
Surrender and obtain bail.
My lord, non-bailable section. If I surrender, I will be taken into custody.
Wait for bail there. Wait for bail.
I have paid for anticipatory. Before the sessions court, that has been done. Thereafter, I am before your lordship, so that your lordship can grant me liberty to deposit the bond. Totally hack story.
Where is the order of the
Coordinate bench. Coordinate.
4th of July? Your prayer was refused.
Man,
Then what is the change in circumstances?
no,
You are shooting. What is your
he did not appear.
Joy Bormon? What is page 9 you have annexed?
Page 9 is the order of the coordinate bench.
Where is the order by which your prayer was rejected by the session?
He did not, my lords, I made a mistake. My learned friend will say he did not approach the sessions for directly for your lordship. My lords, can you consider one thing? The observation of this court by disposing of the CRA 473 of 2023 is that the allegation is omnibus. There is no specific role attributed by any of the persons. Hence, the bail has anticipated bail was granted to other family members. And your lordships. Now, can you see the last page of your lordship? That is the multiplication clause 3, which will be filed by the de facto complainant before the learned ACGM to fund. What lordship should be solved?
Wait, let us see. You can make a proper Xerox copy of the petition. You can read this.
I shall count the time for your lordship so desires.
Yes, what do you say? He is the mother of the deceased.
Yes.
And this is the footnote of the body.
Where is the postmortem?
Yes. Non-conjugal citizen what? Suicide at her parental house, not in my house.
Hmm?
Not in my house. She went to her parental house. She committed suicide over there.
Do you have any children?
No, it's 25 years old. Petition will be your law. And secondly, your lordship will find that the order which has been passed by the court, it meant at that moment of time, no 164 statement was there. This has been recorded subsequently, and the 164 definitely are interested. It could have been an independent witness, I might not have been saying anything, but it is an interested witness. And your lordship is seeing the postmortem.
Wait.
The investigating officer twice in a week.
Investigation is over
Investigation,
or it's continuing?
not yet,
Not, it's on progress. It's in
progress.
She committed suicide in her parental house.
Yes, 1 year back. Allegation,
But your contents do not tally with your pleadings in paragraph 2. Paragraph 4. Informant tried to settle about 1 year ago. Sujoy assaulted her forcefully, took her in her father's custody.
that is there in the consensus clause. Allegation.
Where is your mobile?
Yes, yes.
Where is your?
May I get back to the I have marked some underlined some
He lodged a complaint.
underlined some lines. And this.
না না ছড়িয়ে দেবে তারপরে আমি উক্ত বিষয়ে বক্সিরহাট থানায় এজাহার থানার সেই দিনের দিকে আমাদের করেন কিন্তু প্রার্থী ছিলেন কোনো দোষী নয়।
আমার এজাহার গ্রহণ করেন কিন্তু প্রার্থী সেটা কোনো দোষী সেগুলো
সেই কারণে আমি বাধ্য হয়ে 21,000 21st of April 2022 she committed suicide.
Yes.
Now this 156(3) was filed on 29th of November 2020. Because her complaint was not received
by the concerned police.
But why after 7 months?
That is not but the allegation is
Where is your mobile?
yes. This is the point. This is the point.
You have the proximity is that you have threatened to upload in social media and immediately she committed suicide.
Yes. I shall protect my wife.
You may not, your client has.
I lodge in any condition, I shall meet the investigating officer. Logic, can you appreciate what would be the fate of the trial? Your logic, can you what would be the fate of the trial?
You have an evil intent. So where is your mobile?
I have to take instructions. If it is with me, I shall be handing.
Your mobile cannot be with another person. It really has to be with you. Kindly consider the linkage. Complaint says yes, delayed complaint. Complaint says that you have taken photographs, you are going to upload that of your wife's photographs in social media. So that can be a.
Appreciate.
We cannot appreciate unless you give the mobile.
There is an order of not to arrest. I shall go today itself by and hand over the mobile phone to the IO. He was already committed suicide. even though your lordship has pointed out that there is a delay of.
There will be nothing there in your mobile now. Everything stored in Google Hub software. Google Drive stored.
The way Apple likes to.
If you are of an evil intent, you will certainly.
Can you think one? If the FIR was not registered on that date, when it is, or it was generally what we usually, or any prudent person, that they used to consult, and within a month or within 2 months,
She represented before the superintendent.
it never takes 7 months. Never takes 7
She
months.
represented.
It never
before
takes 7
the-
months. And the FIR has been registered 1 year after the incident. So who are the witnesses? The father of the deceased, the mother of the deceased, the relatives of the deceased. You know, if you look at the field of it, and what purpose should be solved? It shall be taken into custody.
Investigation is still continuing.
My lords, I shall meet the investigating officer once in a day. No
What do
alternative,
you
nothing.
do? What do you do?
Well, it's,
You're a service holder.
no.
They occurred within 3 years of your.
I'm a calculator. Other than the top screen, I use.
In 1 year. Learned counsel appearing on behalf of the petition submits that the FIR has been lodged on April 13, almost 1 year after the occurrence of death of the victim on April 21, 2020. The complaint made by the victims the complaint made by the victim's mother is a belated one. And the petitioner has been falsely implicated in the alleged offense. Therefore, the petitioner pays for anticipatory bail as custodial interrogation is not necessary. Full stop. Next. The council appears on behalf of the state and draws the attention of this court to the contents of the file. He submits that not only the petitioner, but not only the victim was mentally and physically tortured at her matrimonial, but due to the threat of uploading certain indecent pictures on the social media, the victim was induced to take the ultimate step of committing suicide. Considering the value submissions of the parties and the materials placed on record, this court finds that the marriage between the petitioner and the victim took place on March 7, 2021. Shortly after marriage, the victim was forced to leave her matrimonial residence and reside at her parental roof. Thereafter, it appears from the contents of the that the victim was threatened by the petitioner with uploading of certain intimate photographs on the social media. The same induced the victim to commit suicide. Next. In the opposite circumstances, this court is not willing to grant the prayer for bail. Next. Grant the prayer for anticipated bail. According to clearance, ruling is dismissed.
Age.
Nine of the Indian Penal Code. Get the section 6 and 17 of the code. But I'm in custody for 51 days. So if the relationship.
You're in custody for?
51. The petitioner and the daughter, they have a relationship. Both willfully she had left her house with the petitioner. Thereafter she was recovered. Again she left her.
You are, how many petitioners are here? You are,
Petitioner, one of the petition is before law.
charge sheet submitted?
No, no.
You're in custody for
51 days.
You are the person having relationship.
Yes.
What is your age and what is the age of the victim?
My age is 24 and the age of the victim is 17.
17 years. Why also? কি করেছে?
She's a minor girl also.
But why section 6? There is no.
They have
This is the
160
of the girl.
of the.
আমি সোমবার
So to start, very fun with.
Any medical?
Not she.
Page?
Page 26.
That she does not need.
No, the council appearing on behalf of. Appearing on behalf of the division submits that there is a relationship between the petition and the victim joint. Therefore, the allegations made in the FIR are false, and the petitioner has been falsely. The petitioner has been arrested on July 12, 2023, and till date is languishing in jail. Therefore, she prays for the on behalf of. Now she prays for the petitioner to be enlarged on the. That's my approximately on behalf of this. Brought the attention of this court to the case guide and submits that the medical report clearly points towards. No, is clearly corroborative of the allegations made in the FIR. She submits that there are several incriminating documents against the division, and therefore the prayer for bail should be rejected. Considering the rival submissions of the parties and the materials based on the report, this court is of the opinion that that upon consideration of the statement under 164 made by the victim girl, consensual relationship cannot be. This is kind of this book is kind of cannot be in such perspectives of the matter. This court grants bail to the petitioner. The following petitions. Is 10,000
Satisfaction of?
For the additional district judge. Mexican should pause, I mean, the pause. And it should cooperate with the. Next, the petitioner the petitioner shall also meet the
With inspector. Which police station? Huh? Hon'ble.
Inspector in charge for Hon'ble police station. With the unit.
The girl is in the parental house now.
Lordship.
Yes.
Item 9.
Yes. Where your case diary not there? Anticipatory or bail? Bail. Case diary not there. So Monday we have fixed many now. May not be reached. That's a region of one. What are the sections? Also, you also do not know. Yes, next.
11.
Yes.
After this council brief, before I enter into the facts, kindly consider whether my submission attracts the possibility of change of circumstances or not. And because this is the fourth time the petitioner is making the bail application, the last one rejected on 1st August 2023.
First August.
1st August 2023. And the change of circumstances,
Wait, you have annexed that order?
yes, sir. Page 8.
Page 8 is not first. First. Just give us 2 minutes. But decoy.
Decoy.
What is how many days you are in custody?
This is a bail jump case. First, he was arrested. The FIR was on 20th February 2011. He is in page 13. He was arrested on 21st March 2011, and he was granted bail on 19/6/2013. That is after staying for 2 years, 2 months in consideration. Subsequently, Lordship, there are several active persons. The trial could not proceed as because
No, 9. You have 21st March 2011. You were arrested.
and he was on bail on 19/6/2013.
Very good. Then
For 2 years, 2 months, I was in custody.
then what? When were you rearrested?
18/7/22.
18/7/22. Why you were rearrested? You did not
Did
complete.
not appear before the court. In the meantime, the pandemic situation and others occurred.
How? 18th of July 2022. You were.
No, after granting bail, I appeared for a considerable period, but other points also they did not appear. So warrant was that the trial could not proceed. So ultimately, he also did not come out. I'm submitting fairly. So he was subsequently arrested on 18/7/2022, and now still now he is in the custody. 7 accused persons are present in the trial, and in charge sheet will also be find 6 accused persons were shown as absconders. Still, there are 34 number of witnesses. Till now, 4 witnesses examined. The complainant
including the person who was placed before the TI parade. I have annexed that copy also, Lord.
Now, what is the change in circumstance?
Lord, now I'm coming to that. Lord, parade says that characteristics of the relation order.
No,
page
but
9.
what is the stage of the proceedings?
Evidence is going on.
Evidence
No,
order.
it was his 28 July, 31st July, 30th September. All are being appearing.
They have mentioned
Page 9.
31st of July. They have themselves annexed the evidence.
Evidence, where what you will find that one of the witnesses who was placed before the TI parade also failed to identify me.
No.
I'm coming to that line then. What she finally says,
No, why should we go into the evidence, Mr. Ganguly? It is a case you are saying that 1st of August it was rejected.
Lordship,
Page 9, the court says that we do not find any change. Now that was 1st August.
no, sir.
We are in 31st August.
First,
ঠিক আছে, 1st September. One more day. Now what?
if Lordship considers this to be because two witnesses have been examined and page 28.
Mr. Ganguly, what is the change?
Uh,
It is
that is
the
it.
Lavesh Kumar
Yes,
judgment is
yes, Lordship. I'm coming to that.
submission of charge sheet also.
No, I'm not to that. The complainant failed to identify me.
That is a merit point. You are on the point of changing circumstances.
Two witnesses examined, Lordship.
That is, it was there, that was.
So two witness examined, maybe in cross they have said something which is beneficial. It is a matter of trial. Now any direction for expedition disposal of the trial?
Not in the others.
No, Lordship.
But there is a detailed order, passed by the coordinate bench, where they have observed that there is no change in circumstances except the period of detention.
Yeah,
And this is not the case, Lord.
Actually, he was on bail, Lordship. So now he is the question. Lordship, he was on bail. Now the question is, we do not want to go to the merit. He was on bail.
Withdraw it, come after some time with a change. Otherwise, if you suffer another discussion, you will be in trouble.
I'm grateful, Lordship. So you consider this a complimentary point, I have to do this.
You were trying your luck, but what can be done here? On the Mr. Ganguly learned advocate appeal for the petitioner. Submits upon instruction that the petitioner does not want to proceed with the present application.
After the schedule is over,
In view thereof, the application in circumstances.
grateful. Let's say after the schedule is over. Ready? In this case, I have the petition is in custody, 49 is in custody.
Yes.
Yes, your Lord. Allegation was taken 14A and 14C of the Indian Code of the conduct act. So far my content, the petitioner before lordship is an Indian citizen, 14A, now the applicant only 14C applied. The allegation is basically the petitioner harbored the
How long you are in custody?
239 days in custody, in similar circumstances,
And your claim was rejected on 4th July.
yes, your Lord.
What is the change?
Well, I'm in custody, the word, similar.
Only 20 days have gone. You have filed the petition on 18th August. One month after that you have filed. What is the change?
The petitioner is in
Our knowledge kindly. What kindly we will do? What is the change after 4th July? Tell me.
Similar circumstances were granted similar.
When they were granted.
Yes, Harvard is active.
When they were granted.
Yes, your Lord.
When they were granted.
that 23 May,
23rd July,
12 July 2013.
2013.
No, 23 May, this is the latest order.
What, lower court?
Coordinate, similar circumstances, coordinate will granted bail. जो हम लोग application हो रहा है, जो हम लोग
Again, you name the judge. Why do you name the judge, sir? All the judges are colleagues. You just say.
Similar circumstances, the recent judgment was passed, granting bail.
Right, we agree with you, but you tell us why on 4th July it was dismissed on merit. How can we help you? If we go on that point, we have to disagree with this order. That no, the change of circumstances in 2013, in 2023, in another case, another person was done. This is your contention.
No, I am not saying so. The
2023.
case of 2022 million. It's a case of 2022 million. The last year is
Change.
Give your, break it out.
May I submit?
Yes. Yes.
Last election order of coordinate events,
4th July.
4th July. Categorically states the reasons, why it is not inclined to exercise the discretion in their product. But they have antecedents and time exceeding last election order. That is my humble question.
The allegation is in the harboring. Similar circumstances.
In third paragraph. But the petitioners and their lives are threat to national security. They tend to facilitate foreigners to infiltrate illegal into.
That sheet submitted.
Yes, yes. Finally, they are 239.
This is NDPS, right?
This is wrong, no, I have.
But there are similar cases.
Done a counter appearing on behalf of service that the allegation against the petitioner contained in the FIR is incorrect and the petitioner has been falsely implicated. He relied on an order passed in CRN of 2023, passed by coordinate in support of this convention that accused in similarly placed circumstances have been granted bail. Next. Mr. Chaudhary from another council appearing for the state submits that the petitioner has criminal anti-criminals and a coordinate bench of the honorable court has rejected the prayer for bail of the petitioner on July 4, 2020. Therefore, the present petition also to make considering the diverse submissions of the parties and the mediums, this court is of the view that the coordinate bench of this honorable court rejected the prayer for bail of the petition on July 4, 2020. It has been clearly reported by the said one that that similar cases are pending against the petitioner, and the petitioner is a habitual offender. Furthermore, it has been found that the petitioner and their likes are a threat to national security. Threats have been Next. This court is of the view that there is no change of circumstances between July 4th, 2023 and today was started. Accordingly, the prayer for the, this court is not inclined to allow the prayer for the. See that in second part, voting is being.
Yes, next. Yes. How many envelopes you have annexed? Well. আচ্ছা তোমরা তো বলো আগে পরেরটা নাও 500 next 22 আর কি বলছো 500 আর take off 27 yes Mr. Ram. Again NDPS.
The case started on 16/11/2022. I was arrested on 13/5/2023.
16/11/2022.
The case started. I was arrested on 13/5/2023. Accused statement.
Where accused statement?
Nothing recorded. Kindly see the list. I have annexed copy. Page 13. Page 13 of my petition.
Nothing recovered from it. Then why it was rejected?
No, Michael was not rejected. Go accused. From whom this receiver was. I have annexed every copy.
So yes, what is the problem then?
No problem. Nothing has been recovered. I have annexed
Having hardly learned it. Oh, hardly learned advocates appearing for the respective parties and considered the materials in the prima facie as no contraband substance. Prima facie, no contraband substance above commercial quantity has been recovered from the possession of the petitioner, and his name has transferred on the basis of co-accused statement before a police officer, which is inadmissible in evidence. Stopping view there. How long you are in custody?
I am in custody. I have annexed on 13/5/2023.
In view thereof, further detention of the petitioner, who has already suffered incarceration since
13/5/2023.
13/5/2023, is not necessary. Allow 10,000 securities one completion in view thereof, and as investigation is already complete. Further detention of the petitioner, who has already suffered incarceration with such and such is not necessary. 10,000 securities, one local. She submitted. Not to temper. Not to temper and will attend the learned court below on all the dates fixed for here. Yes. Where did he go? Yes, next. अन्य हेलो ये बिलिंग का है देखिए जो बिलिंग कनेक्शन
45.
बोले दो
43. 47.
yes
Run for that, run, my lord.
40
47, my lord.
चलो
Legal aid, man.
बिलिंग कनेक्शन इधर भी who is your other side Follow. Yes.
48.
अरे दाड़ा मामला को
Yeah, my lord.
yes but he is here your other side is here oh अच्छा pass over the 46 you didn't respond
47.
अच्छा pass over but after 47 we will take it. Yes 48
48.
48, Lordship, I'm appearing for the appellant petitioner, my lord.
who is your other side
Lordship, I do not know.
not today next
49.
not today
50.
50 who is there
50. My lord, I have for the kindly accommodate my lord on Monday.
not
51.
today not today
52. 51. 51 minutes.
51 who is your other side pass over
52.
please for this state who is your other side not today yes
Possible matter 47.
your other side 47 your other side is here Mr. Nag you are there which matter
47 and 51.
51 ready.
51 huh?
51, my lord, I am ready. My lord, 52 also we are ready, my lord.
Why don't you respond at the
My
time
lord, I was in other board, my lord.
come on Monday we have made it not today yes then 46 for
46, lord, 46 again.
Mr. Shantanu come on Monday
My lord, 51, it's the time only, my lord. But 9 and more than 9 years, my lord, in surgery. So it will not take much time. I can agree. I'm not entering into
already
a
come on Monday he's having problem all right yes 46 on your other side 46
Says not arrogant.
Yes. 46. We'll check up in the office.
why
File the case.
Actually, it is a old case. Probably they have.
the problem is on Monday we will be having bail you do not know whether it will be reached or not now we are submitting those applications let us see what will happen.
21.
What is your matter 51 what is your matter
52.
yours is 52 or 51
51.
Huh?
51.
51
Yes.
আচ্ছা 51 এর ফাইলটা দাও Yes, still.
She is in custody since 25th of July 2040, my lord, almost more than.
What are the sections?
My lord, these sections are under my lord.
Are you ready?
Yes, my lord, actually, only one brief is there, my lord.
Mr. Nag, wait.
300.
Let him say, let him hear.
My lord, these sections are under my lord 302, 329, 34 and 123, my lord. On the basis of circumstantial evidence, my lord, the court below has convicted the present petitioner, my lord. There are three accused persons, my lord. The principal accused person name is Akash Dotto, and the other co-accused one is Little, and another one which is present petitioner, my lord, Gopal Rai. I'm paying bail for Gopal Rai. This fellow paper book.
Yes. So when did you file the application? Admission of appeal was on 7th June.
Yes, ma'am.
When did you file the appeal?
On 28th of June 23. 28th of June 23, ma'am.
7th of June, your appeal was admitted.
Yes, ma'am. Thereafter, I filed the
Paper book you have filed.
no, ma'am. Grand application.
Yes.
After admission of appeal, I filed the grand application.
You are Gopal Rai and another.
No, ma'am. I'm only for Gopal Rai.
Then who is the other person?
Other person, my lord, I'm not filing a bill for them, my lord, only for Gopal Rai.
Why you are from
Because the
the,
principal accused are two, my lord, and he is not the principal accused. Gopal Rai is not the principal accused. I'm paying bail for only one person, my lord. Accused number 3, Gopal.
was your application earlier rejected?
No, my lord, this is for the first time.
But the thing is, he has to go through the judgment, na? In absence of that, how can we allow?
My lord,
This way it cannot be done. It is a murder case. You are seeking bail in connection with the case. Go through it and come on Monday. Try your luck. What can be?
my lord, then if my lord is on
Mr. Shantanu, we are trying
I'm
our
also
level
understanding, my lord.
Yeah, whatever you have mentioned, we are definitely doing this. Unfortunately, advocates are again not appearing.
The totally, my lord, it is on the evidence of the circumstantial, my lord, there are no direct witnesses, nothing, my lord, no eyewitnesses, nothing. my lord.
Let us see.
If my lord would-
Your application is of June.
yes, my lord. After
I
that,
take it up with it. Like, it's just, it's the-
Order 21. After the city time,
যিনি বেইলিং কন্ডিশন হলে অ্যাপিল যে কোটা রেসপন্ড করেছে যে কোটা একটু উপরে দিতে এই যে যেমন এই শান্ত যেগুলো ওনারা রেসপন্ড করলেন
We are kindly mention for the legal matters that are representing through legal matters. I am happy make correction. If
give the numbers, give the numbers.
the stocks in the top of the list and
No, top of the list, they are not. Before you, we have made other matters upon the list. Yes, what is this one? Try your luck. Yes, tell us.
Also pay below. Allegation under section law 198A, 313, 34 of the Indian Penal Code and section 6 of the Protection of Children from Sexual Offence Act. 198A, 330. The petition is in custody minute 270 days in custody. Petitioner got married with the victim guard and they together at the matrimonial house for considerable time. Subsequently, she got pregnancy and she was suffering from ectopic pregnancy. Your lordship know the ectopic pregnancy means the
She was residing with you.
yes, your lord. She was residing with me.
What is her age?
16 years. 16 years old. And the petitioner is 25. They got love marriage. They are even at the time of marriage, the child, the victim's mother was present at the time of marriage.
So that presence validates your conduct.
But they are in love relation. They got married subsequently. Whatever they
Charge sheet submitted.
submitted 270 days in custody.
Section 6. Now
Examine on the evidence from
victim examine.
yes, your lord. They are loving relation. They are not happy to love.
Don't repeat love. Wait, we have recording.
And so whatever consequences they will face that trial will what happen in the
Base consequences if we reject. Finished. Consequences we will face. It is taken. Your prayer was last rejected on 5th of June.
yes, your lord. The subsequently develop the victim in her evidence stated that they have love relation, their mother was present. Like I have anecdote of the evidence problem.
When was the evidence?
It was evidence will kindly come. Annexure P7, page 19 will.
Wait, page
Page 19 will.
Page 19. Yes, Mr.
We didn't know. We didn't know.
Page 19.
Yes, your lord. Last correction.
করেছো অর্ধেক করো।
Last correction.
When was you examined? 28th July.
Yes, sir. 28th of July, 2023. After page 9.
16 was added.
If you got pregnant, the doctor will take it. He has to comparative.
So miscarriage,
Yes, your lordship, yes.
section given, section
Yes,
given,
sir, that is there, your lordship.
13 is there.
Yes, sir.
Not miscarriage, at least, miscarriage, my lord, he was suffering from like, it could be pregnancy, but I have annexed the page, annexed the E4, page number 6, page number 60. Doctor Miller opined that he was suffering from ectopic pregnancy, Miller. That's why it was necessary to save the victim.
Yeah, just page number 6.
Miller, may I?
Yeah, wait. When was the examination, Mr.? Examination was on 13th of June 2022.
After if I have another.
Yes, sir.
No,
What are
kindly see, Alexa, please, second page, your lordship. Page 20.
Hmm.
Hello, I was,
Yeah, we have seen
Yes,
it ticked on the abdomen.
yes. Hello. Without go through this, reposition of the doctor, it cannot be said that ectopic pregnancy was due to, for which reason?
If you interrupt, we dismiss here. You are finished, please keep quiet. Any other person arrested? They were granted bail.
Father was granted bail.
You are sworn.
Yes, sir.
Yes. Rina Singh.
I am under the legal complaint.
Yes.
After the marriage, after the marriage, the every person return to the victim girl and also demand for dowry.
No, but what is the story that they were having a relationship? The girl went to that house, stayed there, no problem. So section 6. It is doubt. Section 6 is a point is whether 313 section 6 will apply or not apply. We are not on that. She has deposed that I was kicked, there was miscarriage. And their contention is that there was an ectopic pregnancy. But this ectopic pregnancy, what he is showing, that is of 23rd June 2022. But when was that assault? When did he kick you?
That is not.
That is a matter of the trial. No? He has examined in a government hospital,
Yes.
which says, now this has been exhibited. Has this been exhibited?
No, that's only the victim only making it. The only victim has example. Doctor, you have to example. Doctor, you have to example.
2023, June 2020.
Prior to the FIR launch.
Aha.
2022.
কিন্তু
March, April, May, June, July. Ectopic pregnancy.
How many days in custody?
272 days in custody.
In the right now, the victim recently his her parents are also.
Yes, that is.
May I define the ectopic?
If this medical examination was of June 2020, complaint was lodged on December 2020. December, when your daughter came there.
Yes.
But in your complaint, where you have stated that when was this tortured, and it is an immediate because you were given pills.
Yes.
One allegation is you are being forcibly giving pills. Second allegation is that in her evidence she says that he has assaulted you. Due to that assault, there was miscarriage. This is the story you are saying.
Many inconsistencies in each other. Current council, current council appearing on behalf of the petition submits that there was a relationship between the petitioner and the victim girl. Consequently, the petitioner got married to the victim girl and she fell pregnant. Such pregnancy was and ectopic, ECPOPIC, one. Therefore, the petitioner, therefore, the victim girl would not have carried the same through successfully. The allegation in the FIR regarding abetment of miscarriage is incorrect, and the petitioner has been falsely implicated. Next. Another council appearing on behalf of the state submits that there are several incriminatory documents against the petitioner and draws the attention of this court to the statement under section 164 of the CIPC. Statement of the victim girl recorded under section 164 of the CIPC. The de facto complaint is also represented. He submits that the victim girl is now residing with her parents. It was due to the torture committed out to the victim girl by the petitioner, victim girl form by the petitioner, that she suffered miscarriage.
Where is the 164 you said? Sorry.
164. But putting the advantages of the parties and areas placed on this court is of the view that the petitioner is already in custody for more than how many days? 272 days. There are discrepancies in the FIR lodged by the de facto complainant. Primarily, this court also finds that the pregnancy was an ectopic italic syndrome one, and whether or not the miscarriage was due to any act on the part of the petitioner has to be decided at the appropriate stage. Next. This court is of the opinion that no further custodial interrogation may be necessary. Accordingly, it is ordered that, accordingly, format is ordered that the petition shall be released on bail on the following conditions.
Where you are residing? Where is the guard residing?
Parental Hon'ble.
parental house, that is a, where do you reside?
Yeah, 164 statement.
No, the different state because if Bhakti Nagar, I am residing at New York. Different. Lot of liberty, jurisdiction, Bhakti Nagar.
Where does the girl reside?
Bhakti Nagar, yes.
And the boy?
Zero, but I don't have address, place your order.
Yes, shall not leave the jurisdiction of NGPPS.
He will not leave the jurisdiction of NGPPS and will attend the court on all the dates fixed for hearing.
Yes.
This court finds. Further, the evidence of the victim also is already.
His evidence is complete. Yes. on behalf of the
petitioner.
then it will go to the next circuit.
Not one day accommodation, he will.
One day accommodation, we cannot meet it.
Your lordship, the petitioner will do the matter.
Pardon?
Lordship, if your lordship take up the matter on Monday, the petitioner advocate will do the matter.
Monday, I cannot assure you, na, because Monday division means you know what we are unnecessarily, it is continuing in the list.
But if this matter
You-
coming in the list, then. If
No, we will keep it in the next circuit.
lordship.
We will keep it.
Lordship, kindly keep it in the list, if your lordship, get time.
You have to start now. This is the first time it is appearing. Who is your advocate?
Lordship, he left the court, lordship.
He has left the court. He came today.
Lordship.
Who is he? Who is he?
Mr. Shubham.
আমার কি লিস্টে আর কিছু আছে? I think you can talk over with him that you have to serve, na, unless you serve. It is an arbitration appointment of arbitrator. You are not in the matter.
No.
Not today. But we cannot assure you.
Lordship.
Yes.
Lord, I beg to appear in item number 2, my lord, respondent number 4 and 5, Siliguri Jalpaiguri Development Authority.
Who is for the petitioner?
Mr. Ikramul Bari is appearing for the petitioner.
Did file it out? You are appearing for who?
Well, he is assisting me.
What is the matter, Mr. Shah?
No, this is basically the employees of SJDA, Siliguri Jalpaiguri Development Authority seeking conversion, my lord, from CPF to GPF. Now SJDA board has approved it, but the government is, my lord, is not willing, lordship. The government has filed on the last occasion a report. If you lordship kindly peruse the report, it will be clear to your lordship.
No one is here, we are keeping it next. No one appears on behalf of the petitioner. Though Mr. Shah, learned advocate appearing for SJDA is present. No, okay, no, just we are making it, but you are there. Then we are simply making it not today, next week. If I sit, I will take it up.
Or my lord, let it be next circuit. On the last occasion, they took time also. No, they are waiting.
No one appears. No one appears. Click it up. No one appears on behalf of the petitioner. What is the government report? Government has agreed to it.
No, that is the situation, my lord. Now, perhaps, my lord, they will talk to the government or something like that. This is a union, my lord, employees union.
No one appears. No one appears today on behalf of the petitioner, and no accommodation has been sought for. Though Mr. Shah, learned advocate appearing for SJDA is present. So then now we will release the matter.
Lordship, I'm just informed that I am appearing on behalf of petitioner on behalf of Calcutta, sir.
Yes, they are. An adjournment has been read for on behalf of the petitioner. Though Mr. Shah, learned advocate appearing for SJDA is present. In view thereof, please the matter before the next available summons.
Grateful, lordship. Grateful.
I am for the petition.
Yes, sir. What is the matter about?
You looks like a declared order for charge below on the last occasion on 17/12/71. There was an order of recording in bench in which the respondent told that they have constructed the house on taking oral permission from the panchayat. But there is the panchayat.
Have they filed affidavit?
No, they have not filed it. Even the state respondent is also not filed affidavit. Pradhan was asked your lordship to file affidavit. Pradhan, Gram Panchayat Pradhan of Matigara.
2021. The order was of 2021. Construction.
17/12/21, it is detailed order. Thereafter, no.
Now that construction was made,
Construction made.
construction is still existing.
Yes, yes, your lordship, it is clear.
In order, just give me a moment. Petitions and permission granted to issue for this. Where Mr. Bikramjit Ghosh is here. You are Mr. Pardon? More. Where do you decide? Where do you decide? Your client and the respondent number 8.
Right.
They are deciding adjacent area.
No, that's not my written land. There is a dispute of title.
Then there is a dispute of title. Your civil division cases have been disposed of.
We are postal.
So if you are post-orders, allegation is that you initially consented.
No, your lordship.
Respondent is submits co-own. You have a co-ownership.
Attached property there.
Sir, this has to be decided. Why didn't you mention the matter earlier? 2021, the last order was passed.
They are not filed.
How can I help you? You should have come earlier.
Right.
Listen, you do one thing. Tell Mr. Achha, who is the GP then? Who is the huh? Subir Shah? Can you call him?
Yes.
Just for 1 minute, if you can call. When he was hearing was no Vikramaditya Ghosh had a junior. Momenur Rahman. Mominur Rahman is there. I am keeping it in the list. I am keeping it in the list. You ascertain from Mr. this Mominur Rahman. Give me and this Rajot Das, he practices here. Sir, how can I help you? This is
Then you are either subject or with the direction with the direction to appear positive. I will communicate them.
Mr. Mithrukal, learned advocate, appears on behalf of the petitioner, submits that though a direction was issued by coordinate bench of this court way back on 17th of December 2021 upon the respondents, though a direction was issued upon the respondents, way back on 17th December 2021 to file the affidavit in opposition. Mr. Nitu, the learned advocate appearing for the petitioner submits that in spite of an earlier direction on 17th of December 2021, the respondents have not filed their evidence. Is there?
No.
What I will direct, if you can't get the person, let the matter, you are practicing in this court.
No, I am also still
You are of
coming to our from television.
how can we help you if you could have got, because there is a direction for affidavits. Affidavits have not been exchanged.
As per permission granted is under the gloves and hands of the private respondent by ground Panchayat Pradhan. There is a detailed procedure in Panchayat rules.
Then I'm keeping it in the list.
Then you know, you say it will also.
It will be in the list. I am not dismissing the matter for your absence.
No, I am.
If on Tuesday, I do not know whether I would be, when I would be sitting.
Otherwise, you're.
If you are not there, then let us see. If I do not sit, I cannot take up the matter.
Yes, yes.
But if the matter goes out of the list, you will be in problem.
Right, right.
Let it be, not today, put it up. And in the meantime, you can inform your. This in this matter, Vikramaditya Ghosh was appearing. Now, your friend in Mr. Bormon says that that panel has been challenged and Mr. Ghosh is not there.
Ghosh is not there, he has resigned. The thing is that
Yes.
from the state panel, he has resigned, but his resignation is not yet accepted.
No, there is another Momenur Rahman. Is he an advocate in your panel? Momenur Rahman.
His matter is going.
Then please, this man is, he got an order in 2021. There was a direction upon Momenur Rahman on behalf of the state to file an opposition. No such opposition filed. So you please inform him that, so that he can contact with his lawyers and file the affidavit in opposition. Not today, let it be. This year's call the next one.
That is it for.
Yes.
In this case also, it was only that we.
Yes. No, Mr. Government Leader, I would request you, I don't know whether who is appearing in this item form. She is appearing in person.
You are on your state.
Oh, you are on, yes.
In this case, there are other responsibilities. All are parties. We are not.
No, what is the matter about? Let us see. You are there in this matter.
My experience can be reported.
আচ্ছা ওইটাতে একটা অর্ডারটা মিস্টার মিত্রুকাল and advocate appears on behalf of the petitioner. And submits that no affidavit in opposition has been filed by the respondents till date. No one appears today on behalf of the respondents. As a last chance, the matter stands adjourned. As a last chance, the matter stands to give a further opportunity to no one appears on behalf of the respondents. To give a further opportunity to the respondents to appear The matter stands adjourned. Release the matter for further consideration before the next available circuit bench. Before the next available circuit bench on a date now. Next available circuit bench. Not 11, give a subsequent date. You have to communicate this order, no? On 18th, on 18th September, subject to the convenience of the honorable bench. Stop. The petitioner is directed to intimate this order to all the respondents and to file an affidavit of service on the return. Yes, what is this matter about? This writ petition?
Both.
Yeah, just one. Right, respondent number 8 is an advocate.
Yes, my husband, my father is also an advocate.
This has been filed by your father.
Father, but he.
What is his complaint?
My last can I speak Bengali?
Bangla bolun.
My last actually আমার একজন advocate, but আমার বাবা general practitioner না 1999 এ আমার বাবা enroll হয়েছিল as an advocate. তারপর কিছু বছর প্র্যাকটিস করে আমার বাবার নামে আমার ঠাকুরদা কিছু প্রপার্টি রেখেছিল যার ভাগ নেওয়ার জন্য বাবাকে বলেছিল প্রপার্টি আসলে তখন বাবা জেনারেল প্র্যাকটিসটা ছেড়ে দেন আর সেটা আমার 2003 পরে
আচ্ছা দাঁড়াও 2 মিনিট দাঁড়াও Mr. Warren, take it. আপনি চাইছেন বার কাউন্সিল যাতে ওনার বিরুদ্ধে স্টেপস নেন
My last actually আমার বাবা জানলে আমার বাবার বন্ড রেট যেভাবে পর্যন্ত করে প্রচুর বন্ড রেট পাবলিশ হয়েছে দিস না simply like what has about এটা my last কমিটি কোনো বাবা আর্টিকেল লাইফে actually my last আমার বাবা যে এটা আমার বাবা বেস্ট করে না করতে হবে এই ক্যাপিটাল হয়ে গেছে আর এই পিটিশনটা এটা আউট অফ ল হচ্ছে পিটিশনটা আউট করেছি আমাকে একজন লয়ার সাজেস্ট করেছিল যে বাবা করবে না কারণ বাবা একজন লয়ার
না বাবার অ্যালিগেশনটা কি
বাবার অ্যালিগেশন এটাই যে বাবার স্টুডেন্টের সিগনেচার দিলে একটা বলবো
বাবার
পিকচার ফোর্জারি করা হয়েছে
সেটা কোথায় বলেছো পিটিশন
মাই লর্ডশিপ বিরাট ফর টোটাল পিটিশনটি আমার এই সব এটাই
না প্যারাগ্রাফ 6 টা পড়ো approach Alimulo for his case details. Inform that Kaushik Bonika, member of Alipurduar Court and a practitioner of furnishing bail bonds in the name of the petitioner. And on his behalf, as a guarantor surety since now. Thereafter checking such and such, the main fact arises, never gave his signature. তো এই সম্পর্কে তুমি কোনো পুলিশ কমপ্লেইন্ট লজ করেছিল কি? সেটা কোথায়? পুলিশের কাছে যে কমপ্লেইন করেছিলে সেটা কোথায়? পেজ নাম্বার 27. তো তোমার বিরুদ্ধে, তোমার বাবার বিরুদ্ধে কোনো কাউন্টার কেস হয়েছে কি? না না, ওনার অ্যালিগেশন হচ্ছে যে ওনার সিগনেচার ফোর্জ করে ওনাকে গ্যারেন্টার দেখিয়ে সিওরিটি ইস্যু করা হয়েছে, সেটা করেছে ওই রেসপন্ডেন্ট নাম্বার 8, এটাই তো বক্তব্য। তো এই যে তোমার বাবাকে সিওরিটি দেখিয়ে বন্ড প্লেস করেছে, সেইটাতে তো আর তোমার বাবাকে কোনো সময় কি এরকম হয়েছে যে বন্ড ফেল করেছে, তোমাকে কোর্ট থেকে সামান করেছিল?
ব্যাপারটা হচ্ছে আমি যেতে জানাতে পেরেছিলাম বাবার অনেক অ্যাকচুয়ালি একটা সিভিল ম্যাটার থেকে এখানে একটা জানা সিভিল ম্যাটারটা ছিল পার্মানেন্ট ইনজাংশন ডিগ্রি পায় যে জায়গাটা পজিশনে থাকি, সেটা কমপ্লেইন হচ্ছিল না বলে একটা রিপিটিশন করা হয়েছিল এই কোর্টে, যেটা অর্ডার 42/2020 হয়েছিল, আর সেটার মধ্যে রেজিস্টার করতে বলা হয়েছিল এবার এখন কি কিছু আইপিসি দেওয়া হয়েছিল, যেটা ওদের রেজিস্টার করতে বলা হয়েছিল, সেটা ইম্পর্টেন্ট অর্ডার ছিল। সেটা ইনফরমেশন দেওয়ার জন্য যখন আমি আলিপুরদুয়ার পুলিশ কোর্টে যাই, তখন ওখান থেকে
সেই অর্ডারটা কোথায়?
মাইনরশিপ এইটার মধ্যে তো নেই, সেটা সিভিল ম্যাটার, বাট দিস রেসপন্ডেন্ট নাম্বার 8 is also a family member and all these family members are
এই ফ্যামিলি মেম্বার তোমার কে হয় তোমার?
মাইনরশিপ আমার বাবার বড় ভাইয়ের ছেলে। মাইনরশিপ আমার
জিনিসটা বোঝার চেষ্টা, তুমি কি আইন পড়ছো?
I'm paying in person and I'm standing here as power of
That I understand what you are studying. কি করো?
I'm graduate.
গ্রাজুয়েট। তাহলে তো এই কমপ্লেনটা কি করেছো যে তোমার বাবার সিগনেচার ফোর্স করে এই কৌশিক এই কাজটা করেছে, যেটা জানতে চাইছি সেটা হচ্ছে তোমার হয়ে কোনো সময় কোনো অ্যাডভোকেট এসেছিল, নিয়োগ করেছিল কোনো অ্যাডভোকেট? কোনো পুলিশ কেস রেজিস্টার্ড হয়েছে? এইটা কি পেজ 39টা কি? বাবার নাম কি?
মাইনরশিপ 39টা হচ্ছে এফআইআর যেটা মাইনরশিপ এখানে যে কৌশিক বণিক সে আমাদের
রিনা বণিক কে?
মাইনরশিপ ফাইল যেটা
রিনা
আসলে আমার বাবার নিজের ভাই এর মধ্যে জড়িত, সব থেকে বড় মেয়ে উনি এই সমস্ত করতে এদের বাবা তো ভাবে একবার একটু ভাবে চেষ্টা করেছে এই ফ্যামিলির লোক দিয়ে আমার মানে নার্সিং নাকি আমার বাবাকে পেয়েছে ওনার মধ্যে কাউন্টার কেস করে পুলিশ মাইলা
There are several, more than 20 cases.
Oh my God. Lost in between them.
In between them, more than already 8 to 9, 8 prisons. Between the prison and private residence. Pending in action on the police, sometimes. And so far the other affairs are also already, we have filed a report on the, I see, Calcutta. And so there is a report of CGM Calcutta is also.
But justice, it was taken on 12th of April 2023. Court directed that you file an evidence. Court directed you file an 12th of April 2023. First order was 6th March 2023. When the report was.
To file it. I'm not.
Where is your report? That is, you have given a copy to her.
Yes, we have filed.
There is
a report of ACJ Calcutta.
What did he say? What did he say?
He has called the parties in a similar conducted hearing. That's what before that.
Where is that?
Regarding government communication training and what they are also, if you are a degree of civil, institution is also doing.
Where is the report? Can you show me the report? No, no, এখান থেকে বের করো। উনি কি করে বের করবে? Have you been given a copy?
Yes, yes, sir. This was filed.
তো সেটাতে তো তোমার বিপক্ষে হোল্ড করেছে। কমপ্লেন নেই। So on that writ petition, a direction was issued upon the SCJM to conduct an inquiry and file a report. Now, what is the report? What has been said in the report?
Similarity, but I am not sure because it is better for you to handle it. Yes, it is very similar. Between signature of the petition.
What তুমি কি চাইছো? এখন কোর্টের কাছে কি চাইছো?
আমার বাবার নামে যে সমস্ত আমার বাবা অ্যাডভোকেট লাইনে কোনোদিনও কোনো বেলবন্ডে সিগনেচার দেয় সেখানে প্রচুর হয়েছে।
যে সিগনেচারটা উনি দিয়েছেন যেটা বলছো ফোর্জ করা হয়েছে, যদি তোমার ওটা ওই সিগনেচারটার ভিত্তিতেই বেল হলে যেমন সিওরিটিটা তোমার বাবা দিতে চাননি, তোমার বাবার সিগনেচার জাল করে দিয়েছে, এটা হচ্ছে তোমার বক্তব্য। কিন্তু কোন সময় থেকে কি তোমার কাছে কোর্ট থেকে নোটিশ এসছে যে ওই লোকটা ফিরছে না, এবার তোমার থেকে আমি ওই সিওরিটির টাকা চাই? তাহলে তোমার ওয়ারিটা কোথায়? তাহলে তো এই জিনিসটা দাঁড়াচ্ছে না। যদি ফিউচারে হবে কি না হবে সেইটার জন্য তুমি এখন কি করে বসে থাকবে বলো?
But my lordship, mainly will not have conditions. প্রচুর রয়েছে আর আমার লর্ডশিপ এর মধ্যে ক্যাপার বাবা সিভিল ম্যাটার্সও আছে আর আমার লর্ডশিপ
করে তোমাকে হেল্প করা যাবে আমি তো বুঝতে পারছি না। So who will explain this thing to the heart? Mr. Ghosh was appearing for Ali. So when the Bar Association complaint has been, Bar Association has also filed a report.
No.
Just referred to in
They
the.
are not.
Suppose the issue in this court is of the found there is no scope for affidavits are required to be called. Now this respondent number 8 is never appearing.
No, that is not, because the main task of the case was in private respondent and then it could get the degree in favor of the citizen. Execution is pending. And then there is a task of the reserve and we have to lodge a complaint and register a case.
No, before the CJM, the SCJM, the respondent number 8 also did not appear. No,
Yes, appear and we have to put it.
found absent on the time.
No, that is passport.
my lord,
On 27 to 2023, coaching for report number 8, this is my chamber to pay the inquiry. So what this issue is, we cannot.
Then it is better that the matter remains pending. Because her father is sick. Today, if any of the surety bond fails, then father will be issued notice.
Because their main allegation is
But they are helpless now. What she will do, if I give a surety, if I am the guarantor, if the person who has been granted bail escapes, then the court will call me. Then the court will call me and say that give this much of money. What is the deal? So her father is sick. She is continuing with the litigation for so many days. Innumerable bail bonds have been filed. Nobody knows when he will be hauled up. If the matter remains pending, at least if in the meantime any such steps are taken, she can come and say before this court that I have already said that and signature is forged.
address CGM can be directed that.
So CGMS says that I cannot.
He can say his signature. But admittedly, his father is registered.
Admittedly, his father is a registered surety.
But they have not put signature. Or any activity.
That is his contention, that I have not signed.
No, but admittedly he is a registered.
my lordship, how
He can withdraw file an application that I want to withdraw my.
my lordship, আমার বাবা রেজিস্ট্রেশন কি হবে সেটাও জানি না my lordship, এখন পর্যন্ত আমার একটা কেসও হয়নি সেগুলো। Even my lordship,
তোমাকে ঠিক বোঝাতে পারা যাচ্ছে।
Communication one time there.
and my lordship, আরেকটা ব্যাপার আছে, full একটা certified
Mr. Bormon, you file an affidavit stating everything. You are for the state. You file because there was an earlier direction upon you. Have you read the?
I am not aware of that order.
Yes, please see the order.
my lordship, আমাদের উপরে অনেক কিছু চাপ আসছে আমি ম্যাটারটা কি আর সেটা ভারত সিস্টেমে করছে my lordship, কোনো একটা কিছু রিলিফ যেটা
There is informal direction of upon all the respondents to file.
No, what I ask you is. He has lodged certain complaints on the basis of which a police case was also investigated. No, you incorporate that in your affidavit. File an affidavit stating all those facts. Let it be on record. And we have already got the letter of the CJ, that inquiry report is here. You file the, whatever steps have been taken, you bring it on record. OC is there. What?
Police report, there is everything is there. We have filed police report also. They have inquired.
No, 12th of April, a direction was there for opposition. So you enclose that in the form of an affidavit and file and give a copy to her.
There will be that order in form of report form that will be because.
You will file an affidavit, report in the form of an affidavit also, he has to come and appear. You are appearing for which respondents?
I see, the response was there.
2, 6 and 7.
And
Ghosh and for the district judge and everybody,
that is.
that is the High Court administration.
Given application given from. Because all they are now judicial.
Notice, can she send notice also the upon this respondent number 8?
Yes, so much I have the service.
Also hard.
Now, the absence of the respondent, very difficult to submit. They are about the.
Respondent number 7, private respondent number 8. He has never appeared before this court. Has he ever private respondent appeared করেছিল?
Police, registered on a private respondent.
These are allegations, they have already more than it's, we have filed a report also.
Private respondent, 8 to something. This is the one, generally other
Already, if you are telling to this, what you will do that relatives.
only
Records reveal that by an order dated 12th of April 2023. In a posted in a hidden good Miss Shunarita Boni. A constituted now and in person represented by his daughter. Hard Miss Monique representing the petitioner. Hard Miss Monique, appearing Hard Miss Monique, representing the petitioner. Stop. And Mr. Stop. Records reveal that by an earlier order dated 12th of April 2023, the parties were directed to exchange their evidence. Stop. Mr. Gormon learned advocate appearing for the state pressed for extension of time to file the affidavit in opposition. Stop. Let such affidavit in opposition be filed within 2 weeks. 2 weeks, within 2 weeks from date, with a copy to this morning. I give a copy to her. Affidavit in opposition, send a copy to her. With a copy to this morning. Stop. Reply thereto, if any, be filed by the petitioner within a week thereafter. Stop. List the matter before the next available circuit bench. A copy circuit bench has Eh? 11th is the next cycle. June
11 থেকে 22 তারপর মাইলট আবার 23 থেকে স্টার্ট হয়ে যাবে
20. তো আজকে কত তারিখ? 2 weeks বলেছো না? আচ্ছা 25th এ কি থাকবে?
25 তে হ্যাঁ 25
ঠিক জানো? Within a week, release the matter for further consideration.
My lordship, এই private respondent এইটার against এ কোনো একটা স্টেট যেটা পুলিশে যদি নেয় কোনো একটা রেজিস্টার হয় my lordship it is not there because
Wait.
With the matter of
Further consideration. Further consideration on 25th September. Subject to the convenience of the honorable bench. Stop. ওইটার আগে একটা লিখো no one appears today on behalf of the respondent number 8 and no accommodation has been sought এই যে মামলাটা আসবে তুমি তো নোটিশ দাওনি অপরপক্ষকে
yes my lordship
14th June ম্যাটারটা অ্যাপিয়ার করেছিল তখন তুমি অ্যাপিয়ার করো
my lordship not listed my lordship
14th June you did not appear.
My lordship, I have acted but the name of the petitioners not.
Yes, but when extension such benefits such affidavit in opposition be filed within 2 weeks, reply there to any be filed within a week thereafter is the matter of it. Can you communicate this order to respondent number 8? Has he ever appeared?
No.
Notice was sent to him.
Yes, no, that one I have been
Where?
my lordship,
Records reveal that in spite of service, none appeared on behalf of the respondent number 8 on repeated occasions. And no affidavit in opposition has been filed by the said respondent. It is made clear that in the event no affidavit, it is made clear that in the event on the returnable date, no one appears on behalf of the respondent number 8 and no affidavit in opposition is filed, as directed earlier, this court would be constrained to direct personal appearance of the said respondent. He is also a practicing advocate.
my lordship, I still want my lordship আপনি যে বলেন যে কোটা করে কোন বলেছি কিনা সে একটা ম্যাটার মেইন স্টেজ দ্য only has 6070
সেটা নিয়ে আমি জানি না whether he is your brother, respondent number 8 is your cousin, you are residing at the same place.
Yes, my lordship, not at same area but in same district.
Has he ever appeared in the writ petition? The petitioner is directed to কি 9th October ওই উইকটাতে কি সার্কিট বেঞ্চ আছে
9th October
আছে আচ্ছা তাহলে পিটিশন will I keep it prior to the pujas or you will do it after the puja?
As soon as possible because they are pressuring upon us. To get ready for it.
Well, is the matter for ওইটাকে তুমি কত অক্টোবরের
25 করেছিলাম
25 করেছো?
সাবজেক্ট কনভিনিয়েন্স
স্যার দ্য সেকেন্ডের উইকটাতে কোনো ইয়ে নেই?
সেগুলো তো কভার করবে না তো 3 সপ্তাহ
3 সপ্তাহ মানে আজকে তো
হ্যাঁ।
আজকে 1 তারিখ,
হ্যাঁ 3
8,
সপ্তাহ
15, 22 3 সপ্তাহ নেই। আর ওকে কমিউনিকেট করতে হবে তো 1 সপ্তাহ বেশি। কবে দিতে বলেছি? কেন কমপ্লিট হবে না? কেন কমপ্লিট হবে না? টুডে
তো ঠিক আছে
না, হি হ্যাজ টু কমিউনিকেট না, সেটা কি 3rd অক্টোবর কি সার্কিট বেঞ্চ আছে?
কন্টিনিউ
তো on 4th October, on 4th October,
রিটার্নেবল 4th অক্টোবর
and the petitioner is directed to communicate this order to the respondent number 8 immediately and to file an affidavit of service. We have extended the time for opposition. He will give you a copy within 2 weeks. Whatever you have to say, you say in your reply and communicate this order by which we have said that if he doesn't appear, court will direct his personal appeal.